We are live, people. This is going to be a first of a kind in that it's not going to be a discussion. It's going to be something of a formal debate. For those of you who don't know, the lawyer is in attendance, and I suspect everybody does. Nate Broady on the upper right-hand corner, Robert Barnes on the bottom. Robert Barnes has been on the stream, I think it's now 2, if not 3 times. It's 2 or 3 times. And we've had some great discussions on the streams about Nicholas Salmon, the Salmon case, and about the impeachment. Nate Broady and I have become friends on the internet as well. And Nate's been on, we've done live streams now 3 or 4, maybe 5 times.
Yeah.
And we talk about all sorts of things. And in the context of this impeachment, the Trump impeachment, there's been some disagreement over essential questions of constitutional law. And I did a live stream with Robert Barnes 2 weeks ago, give or take, where he, I don't want to say brainwashed me, but he successfully convinced me that what I had believed prior to could not be justified. And then I subsequently did a live stream and talked with Nate. And Nate says, no, I disagree with Robert Barnes, and here's why. And we've got into this whole discussion as to, you know, why Robert is wrong, why Nate is wrong. And I said, I'm just not able to navigate that discussion or like know what to argue to each person to prove what the other one wants to prove. So I reached out to Robert and Nate and Dershowitz, but he did not respond, and suggested let's do a live stream debate of sorts just to deal with, I think it's basically 1, maybe 2 questions with a subset of issues as to impeachment. What is an impeachable offense? Does it need to be an actual crime or crime-like? And the sub-question, which was going to be, does SCOTUS, the Supreme Court of the United States, for anybody who's not from around here, do they have the right to interpret a congressional or a Senate interpretation of what a high crime and misdemeanor is? Okay, and a brief introduction. Robert Barnes, for anybody who doesn't know him, litigation attorney, has done some high-profile stuff for Ralph Nader, Wesley Snipes, most recently, because that's what everyone asks, the Nicholas Salmon, not Nicholas Salmon, but the Covington Catholic kids. Nicholas Salmon is being represented by L. Lynn Wood and McMurdy. Robert Barnes is representing the other unnamed Covington Catholic kids who are suing a bunch of celebrities, including Kathy Griffin, Azran, what's his name?
Reza Aslan.
Reza Aslan, and a bunch of others. And Robert Barnes is well known. I don't want to say notorious because that has bad connotations. Well known. He's amazing. He's a wealth of knowledge. Anybody who saw our live stream on impeachment would know, and takes tough cases. Nate Broady, New York cop turned attorney, has also a wealth of knowledge. Used to teach, still teaches at university. Wealth of knowledge, and I consider myself to be at the undoubtedly the least knowledgeable of the bunch here, which is why I can't carry this discussion on myself. So we're going to do this. We're going to have like a discussion, and it's going to be something of a debate where we're not going to have formalities, no time things or anything, but we're going to have the discussion about these 2 points and leave it to the viewers to decide who's convinced by what. And just as a matter of pure technical stuff, super chats I will get to. I don't want them to interfere with the discussion, so I'm going to try to take screenshots or whatever, but I'm going to get to them. If I miss anyone, forgive me, but we're going to get to them in as much as possible. And with that said, one other thing. Tomorrow night, live stream with Ezra Levant. For anybody who's from Canada and knows who Ezra Levant is, and even the people in the States, I suspect will know, Rebel Media has some issues with the Canadian government, Canada Elections Act. Live stream tomorrow night, 7:30. So that's some free publicity for that live stream. With that said, Robert, Nate, who wants to start? Does anyone have any introductory statements? Oh, wait, one last thing. Nate's got an uphill battle because Trump was just impeached on the impeachment. So with that said, who wants to start?
I mean, I think I'll give like both sides quickly. I mean, I think the argument that's on the side that impeachment does not have to be a crime or a criminal-like conduct is largely the majority of the legal academy currently holds that view and has held that view mostly steadily since the mid-1970s. The second argument, it would be from different components of the historical record, which is not a particularly perfect historical record in terms of interpreting the meaning of impeachment in this provision. There's not a lot in the debating about what the offenses should be at the convention. Not a lot of debate at the time the Constitution was passed, and the first high impeachment trial of a high officer doesn't take place until 1805, which is about almost 20 years later. So the arguments that they have that are for the not being a crime, in part, are the lack of historical record that clearly shows the other direction. And then secondarily would be the British example and the British history, which is that the Brits used broad language to impeach and repeatedly impeached for non-criminal activities, and that the Constitution didn't necessarily exclude that by express reference. And then third, what the legal academy is today. I think some of the policy arguments that are on Nate's side of the aisle are just, it's really about how much you see the presidency as about, it should be a beacon of integrity that is checked by the little d Democratic elected Congress, versus how much you see the president as a directly elected official who should be largely immune from Congress and subject primarily to re-election. So, and this debate actually goes all the way back to the beginning of the country. So I think there's good arguments and good debates on both sides of the aisle, intellectually, historically, policy-wise, and I understand the arguments from that side. What was surprising to me when I was back during the Clinton impeachment was that the side that of the Dershowitz side currently, that impeachment needed to be criminal-like conduct or a crime, I would go further and say a crime, was not being made very much at all in terms of the discussion. The Academy mostly had excluded it as a subject of debate. Yet if we go back before 1974, the Legal Academy from about the early 1800s, where then you don't have lots of writings, but you have some evidentiary treatises and things like that. You have some law review articles beginning in the 40s, 50s, 60s, in the 1800s. All the way really through 1971, the last sort of major impeachment law review article I saw, overwhelmingly thought impeachment needed to be a crime-like offense. Nixon is what changed that. And Trump, I think, doubled down because the Legal Academy leans left, or at least anti-Trump, even those that are on the Republican or conservative side of the aisle in the Legal Academy don't tend to be pro-Trump. I think that's where the political motivation has come from to interpret it in a certain way. But I think there is a robust debate to be had. But I think definitely it's a robust debate. I don't think the anti-Dershowitz side, just because it has the majority of the Legal Academy, necessarily has the conclusively persuasive arguments on the subject.
Nate, go for it, because I know you had, when we were discussing this, you had some solid, some what were prima facie solid arguments relying on one decision or one precedent in particular.
Well, I think the argument on whether impeachment should be a crime kind of pulls down to two issues. The first issue is who decides what high crimes and misdemeanors are, and there's a doctrine in the constitutional law called the political question doctrine. In 1993, the Walter Nixon case, obviously, the Supreme Court, a unanimous Supreme Court, made it very clear that impeachment was a non-judiciable action by Congress. One of the quotes, I think I have it here, from Chief Justice, let me see, from the Chief Justice, now forgetting the Chief Justice's name, is the one right before Roberts. He says particularly, judicial review would be inconsistent with the framers' insistence that our systems of one of the checks and balances. In our constitutional system, impeachment is designed to be the only check for the judicial branch by the legislature. Now, I actually disagree with that statement, because I think there's another check, and that's the check of whether they can how Congress can expand and shrink the court in Article 3. I think that's another check to the court system. But who am I to disagree with Chief Justice Rehnquist and says that he says that's the only check. So when it comes to who can decide what checks and balance, what high crimes and misdemeanors actually means, I believe the court isn't allowed to determine that based on Rehnquist's argument about checks and balances, because he says also in that opinion that if the court is able to decide what in that case it was try, what try means in terms for Walter Nixon, then the court would actually have the ultimate power in impeachment. You couldn't impeach a federal judge because the court can then overturn it and say, no, that wasn't good enough. The second argument that generally has convinced me why it doesn't have to be a crime is just all of the impeachments previously had some elements of crimes, and some were just crimes, but then some were crimes but non-crimes. Like, for instance, I know we're going to talk about obviously Judge Pickering, because I was slapped in the face with my colleagues at the law school, and I was talking about, hey, what about this impeachment crime? Pickering, he's impeached for drunkenness. But there was a lot to go in that. He was actually insane, and he was unfit for the federal bench. But then you do have a judge who was impeached for absolutely nothing. There was the congressional record at the time. He was officially impeached and the vote wasn't recorded, but he was impeached, and there's no record of what he was actually impeached for, except for a committee note that says that he was, the exact quote from the committee was that his sobriety was the exception and not the rule. It was the House of Representatives. It was Judge DeLahey. It was right after actually the Andrew Johnson's impeachment. So this being a political issue, I think the Senate, who judges impeachments, can obviously lay that, say, we need the standard of having a crime to remove the president. But the impeachment itself, I think, is a non-justiciable doctrine, and that high crimes and misdemeanors are what the House of Representatives decide they are, and that the precedent, even going back to the first impeachment and even to the impeachment of, like for instance, the impeachment of Bill Clinton, one of the articles was abuse of power. Against Richard Nixon, I think one of the articles was abuse of power. And even in President Andrew Johnson, the 10th article of impeachment was disrespecting Congress. Now, even though I do know, some of the arguments may be, well, for instance, Andrew Johnson, there was a whole bunch of articles of impeachment, articles, and, some of them were crimes and some of them weren't crimes. But the fact is, if he was convicted on the 10th article of impeachment, he would have been impeached. And, it was generally for disrespecting Congress. So I do think with Robert Barnes is saying is 100% correct. There is a robust debate. But I think if you just look at the history and the 1993 ruling in the Nixon case, it makes it very clear that impeachment is really in the purview of the House of Representatives, and they can generally seem to impeach for almost anything. The crime requirement, I think, is less an argument for impeachment and more an argument for conviction.
Yeah, I think in terms of the power to decide, which I agree is separate from, there's an objective definition of what high crimes and misdemeanors means. And then there's who gets to decide what that means and whether that's independently reviewable separately from whoever it is that decides initially. And so and I see those two different questions. Like sometimes a lot of my friends during the House impeachment part of the process were arguing, well, look, the House can do whatever they want in the impeachment process. They don't have to be bound by this limitation or that limitation. And I understood they have the power to do so. That didn't necessarily mean they were correct. I mean, the argument was, do the rights of due process and rights of confrontation, and do they apply to impeachment? Is impeachment quasi-criminal or is it purely civil? And recognizing that there's no way to review the House's power doesn't necessarily mean the House's exercise of that power is constitutionally correct. It just means there's nothing we can do about it. It's similar to the same argument. The Supreme Court may say the Constitution means something, doesn't mean they're right. It just means that we can't do anything about it. That's it. Unless you're Andrew Jackson, and then you say, well, you've issued your opinion. Now you can go try to enforce it. Go find that U.S. Marshal that they've been talking about these days. So I think that's one part of it. I think as to I have a contrarian take on whether the court has a role in presidential impeachment, and it's predicated on two things. One is that while the Nixon decision was unanimous, there were like 4 concurrences. Yeah, and everybody had their own little interpretation or variation. And theoretically, they left a thread that somebody could later on pick up and sort of unravel aspects of it. And essentially, the argument would be that the word trial is something that's non-reviewable. Yeah, I hate the word justiciable.
I know, I hate
S and T and C all combine one another. So it's just a trap to screw up the word. But effectively non-reviewable. I use non-reviewable instead. Yeah. So the non-reviewable decision by the Senate, the definition of what is impeachable might still be reviewable by the courts for 2 reasons. One would be it's the Powell decision. So Clayton Powell Adam Clayton Powell, who I really like, a famous congressman, recently portrayed in Godfathers of Harlem, a great TV series with Forrest Whitaker. His father-in-law lives out here in Vegas. I met him a couple of times at the suit shop. Cool guy. A great show too, by the way. But Powell is Powell, by the way, who was also sued for libel. So it was just interesting related to the whole Covington case, just a random tangent component. He was successfully sued for libel. Somehow Senator Warren is outside of the Powell rules. We'll get to that someday down the road. But the nature of the dynamic was the House expelled him, and the House's argument, and Powell sued, and Powell said, you know what, the House may have the power over how they try me, and the House may have the power over expulsion ultimately, but the House does not have the power to define what is subject to expulsion, since that is specifically and separately defined in the Constitution. And the Supreme Court took up Powell's case, and they agreed. They said all of the other aspects of what the House does as it relates to expulsion is non-reviewable, but what they expel him for, that and whether that conforms to the constitutional constriction on the House's power to expel, that is judicially reviewable. So that would be my first argument, is that the definition of high crimes and offenses, of high crimes and misdemeanors, is equivalent to those provisions, or equal to those, comparable to those provisions that related to Powell's case. The second part would be that was in Nixon's case, that Rehnquist didn't like the fact that the judiciary was going to be reviewing impeachments of the judiciary.
Yes.
And so I think here what's different is, one, the Constitution has an explicit role for the judiciary, though this is another area that's completely undefined. Justice Roberts, the biggest precedent we have is Justice Roberts' one-sentence answer to Senator Schumer, which was, I'm unelected, so I'm not getting involved. Impeachment's unique for us as lawyers because we don't have our normal precedents. We don't have our common law precedents. We don't have our court precedents. We just have how the House tries it. We have how the Senate tries it, and occasionally an expulsion or like the Nixon case, maybe the courts make a decision at some point related to it. But their court's role is so constricted. And because Nixon was a judicial impeachment case, my argument is that there's a good argument that the Supreme Court should not be involved, because then the judiciary is controlling the judiciary. This is my argument, by the way, against the entire way we operate the bar in the United States. We have a tripartite separation of powers for a reason, except in one area, the licensing of lawyers. The courts control the entire legislative process, what rules govern lawyers, how they're licensed. They control the entire executive process. They decide who gets disbarred, who gets suspended, and then they get to adjudicate their own actions and their own rules. What's the point of having a separation of powers when you have one branch running that area of practice? And most notably, it's the area that could most expose corruption in the judiciary, because the legal profession will know corruption and abuse in the judiciary better than anybody. And yet the judiciary controls their ability to even practice, their ability to even make a living. So in the same sort of construct of tripartite separation of powers, the impeachment does provide for a chief justice to have a role, even though it's sort of formally in the trial role. And in that context, the same logic would apply here, where we should be able to, the court should have a role in interpreting high crimes and misdemeanors, because it is a term explicit in the Constitution that would be consistent with the Powell precedents, that would be further consistent with the Chief Justice's explicit role in impeachment. It would not be contrary to separation of powers, because they would be reviewing the legislative and executive interaction, not their own judicial bodies controlled by the legislative branch. And I think that's why my argument is, in fact, I argued before Trump went in that, it would have been fun to see him try it, do an original petition before the U.S. Supreme Court to request whether or not these articles of impeachment constitute constitutionally cognizable articles of impeachment under the Constitution. He wasn't interested in dragging this thing out. He wasn't interested in the conceptual law of the issue. He was ready to be done and move on. But from a legal perspective, it would have been great. And I talked, Rudy picked up on the idea, and then Rudy Giuliani, and promoted the idea, but it just didn't go anywhere. I think had he been removed, had there, let's say something politically crazy had happened, and 2/3 had removed, I think then he would have contested it and challenged it. Probably would have moved for a stay pending the adjudication of it. And then we would have had a fascinating situation. Nixon may have done the same in 1974 until he started losing too many votes. And most importantly, if they had not given him the pardon deal, if Ford hadn't agreed to do that, Nixon probably would have fought it all the way through to the U.S. Supreme Court again a second time. And he had put, I think, 4 of the justices on the Supreme Court. Now, he'd also tried to impeach one of them, so that's another story. But so I think that's the component on who decides argues on the issue. But I think it's basically a completely unknown issue in the sense of there's no court adjudication on it whatsoever on the scope and scale of presidential impeachment.
Okay, so two questions for the benefit of everybody. These are my questions, not necessarily anybody else's. Presidential impeachments, we know there have been 3.
Yes.
Judicial impeachments, roughly how many have there been in the history of the United States?
In terms of convictions, I think 8.
Yeah,
I think there have been more than that in terms of ones that didn't reach a conviction stage. Usually what happens is they resign.
They resigned before.
Yeah. Walter Nixon was unique. He was in prison and still pretending to be judge.
He's still getting his paycheck. He was still getting his paycheck.
He's still getting his paycheck, and he was demanding to, I guess, make rulings. I mean, the way the American judiciary has tried to handle this to avoid these kind of conflicts is they internally suspend judges now for problems like alcoholism, problems like mental health issues, physical health issues. There's several judges that I've had the unfortunate being in front of who've subsequently been suspended for anger issues and bias issues. So you have all of that component. And the judiciary's done. Breyer, for example, has pushed heavily for judicial self-regulation because Congress has been pushing for more and more areas. And Dershowitz's argument on it was interesting. I thought there'd be a lot more arguments on this. It showed me how much the Senate is completely uneducated on the historical background of this. They weren't able to make informed questions on either side. Instead, they just sort of, the ones that didn't like Dershowitz just sort of marginalized his view and said he said something that he actually never said. And instead of just, go to the merits. I mean, there were plenty of arguments on that side. Tribe had written articles on this. Another professor at Harvard who believes impeachment has to be a crime, but that abuse of power fits it under a common law definition of criminal activity, had written an op-ed in the New York Times. It was astounding to me that nobody on the anti-Trump side of the equation, not Romney, not anyone, asked questions that went to the heart of this to Dershowitz, because Dershowitz's only answer on the question of this disparity between judicial impeachments and presidential impeachments, both in terms of their number, but also in terms of what the terms were. In other words, some of the judicial impeachments, as Nate notes, have been very vague and have gone through on obscure terms historically. And when you get back into the political record, you find out, okay, a lot of these guys were like, they went nuts, or they were like totally drunk, or they were like falling off the bench. And because there wasn't an effective internal self-regulatory mechanism at the time, the only remedy was impeachment prior to like the early 1900s. That's the reason, and that's why you don't see that after that. But you don't have a lot of precedents. And Dershowitz's only argument to this was he thought the good behavior limitation on judges made judicial impeachments entirely historically unanalogous to presidential impeachments, which I disagreed with him on because I thought the Justice Chase impeachment was the best historical record we have of what people at least close to the time of the founding really thought. But that was it. And I thought I would hear more argument on that. I mean, here we have one of the only impeachments in American history. We have these huge constitutional questions at play. And strikingly, there wasn't a lot of rebuttal to Dershowitz on the Democratic side, other than sort of he believes that Trump can do anything as long as he's doing it for his reelection, which was a misconstruction. They could have debated him intellectually and honestly. There's a strong intellectual argument on that side of the aisle. But unfortunately, we really didn't get much of it from the U.S. Senate impeachment trial, which I think did a disservice to the public. These are unique opportunities to educate the ordinary person, the everyday person in the country, for those that are interested about the constitutional issues that govern our country. And so I see that from the legal perspective. I see these as political events, but I see these as opportunities to argue for particular positions and also to sort of have an educational role and an informative role in that process. Unfortunately, the trial itself I found to be one of the least informative that I've ever witnessed. So
I agree with you 100% on that.
One question now, Nate, for this one will be for you. Okay, so Robert said something to the effect that the reviewing judicial impeachments might not be analogous to reviewing presidential impeachments because that would be the judiciary reviewing the judiciary. The question then, what was my question? Well, the question is this then. The power for the judiciary to review. I mean, is there any legitimacy, or what would be your take on the distinction between the judiciary not reviewing judicial impeachments but having the ability to review presidential impeachments?
Well, first, there's a lot to unwind there. First, the power for the court to review anything, the judicial review, obviously Marbury v. Madison, is a self-endowed power, right? It's not going to be found in the Constitution. Marbury, it was kind of like, we're going to wake up this morning and Justice Marshall was like, how am I going to get out of this? Well, guess what? Let me just take as much power as possible. And, then I can review. Now we have judicial review, and it's been unchallenged, because who would you have to challenge? You'd have to go to the court to challenge their power. So judicial review is now more or less written into the Constitution without being written into the Constitution. So the court self-limits that power, because it's judicial review is so powerful that the courts could just go wild with it, right? And the courts, this doctrine of justiciability is one of those doctrines that the court imposes self-limitations on itself, so it doesn't become this superpower, or it doesn't become superior amongst the other three branches. So when we're talking about understanding what the court can do and how it limits itself, the doctrine of the political question doctrine is one that's firmly grasped in that self-regulation of the court. The difference between I do agree. I think the difference between judicial impeachments and presidential impeachments is something that I think may be internal to the legislature, but I do believe that the court itself, in limiting the power of impeachment to a political question, has determined that the legislature, the textualist argument that the legislature and the article, I keep seeing the articles of impeachment. I don't know. I got Trump on the brain. The textual argument that impeachment, that the sole power to impeach is with the House of Representatives, the sole power to try impeachments is with the Senate. Every court, every Supreme Court justice who's interpreted that has interpreted that to mean that that power is firmly grasped within the legislature, and that's been reaffirmed even in Nixon in '93. So that was the first part of my understanding of why high crimes and misdemeanors or anything in the impeachment process couldn't be reviewed. So even if I firmly believe if President Trump were to be impeached and were to then go and say, well, this isn't a high crime and misdemeanor, the court would review to hear that case. And I think the citation would be Walter Nixon. Now, would he be successful or not? That's obviously, up to them. But I honestly believe that would be the outcome. Now, concerning Dershowitz's argument, I think Alan Dershowitz, I think he's probably one of the best attorneys on the planet. I love Robert Dershowitz. I just want to make it very clear about that. My problems with his argument are kind of threefold, and I'll just start with one, because if I don't want to lay them all out, because it'll be hard for us to go back and forth with them. But the first thing is that he starts with the Andrew Johnson impeachment, and he cites Benjamin Curtis, he cites William Everett, and he cites Senator James W. Grimes, and he cites, and the last one, Senator James W. Grimes, for instance. I had to read up on the impeachment of Andrew Johnson, which is fascinating. If anybody, if you're a legal buff, you read up on it. It's fascinating. But he cites Senator Grimes and says that Senator Grimes, said, I'm not voting. He was a Republican. It was one of the 6 Republicans who voted against the impeachment to save the presidency. So Grimes is quoted as saying that, he voted against the impeachment because, it wasn't a crime, and, he was saving the presidency. He was convinced by Justice Curtis's arguments. But I think Dershowitz failed to realize that later on, they believe Grimes took a bribe for his vote, and if you look through the record, Grimes, it's very likely that Grimes took a bribe, for his vote. And some of the other Republicans who switched sides took bribes because they got huge advances and stuff. So, I don't want it to be an ad hominem attack, but if you're going to say the guy voted against impeachment because he's convinced by the argument, then at least mention the guy was bribed to do it. You know what I mean? I think that would be relevant to the conversation. The second thing is that he did mention Justice Benjamin Curtis, and I have to say this: Justice Benjamin Curtis, his dissent in the Dred Scott case is now the law. Like it was, he was the one, he dissented, and he is one of the premier justices that is amazing. But he was an advocate. He was an advocate for President Johnson. And in that role, his arguments, I don't believe, are legal precedent. And the fact that he was successful in his arguments for impeachment, let's set aside the bribes, that he was successful in his arguments for impeachment, I don't think are enough to convince me that because he was successful, then that means that President Andrew Johnson that now impeachment means crime. For instance, President Clinton's lawyer, he was successful in defending President Clinton, but I don't think anybody would say what was it? It was perjury and obstruction of justice aren't impeachable offenses because he was successful. You know what I'm saying? So if we were to use the logic in the Clinton impeachment, then it would almost become laughable. But then we're using it in the Johnson impeachment with the bribes and everything. So it just becomes less convincing when you actually look into the history. And just my last part about Dershowitz's argument is that his argument goes into the conflation of the precedent of impeachment. And when you just look at it, it's true. Most of the judges who were impeached for this for lesser crimes, drunkenness, and obviously we were talking about delay, where nobody even knows what he was impeached for. He was impeached, and nobody even knows what he's impeached for. He resigned because he was like, I know they're going to convict me. But even in that sense, presidential impeachments have been crimes and haven't been crimes. And the counter argument has always been, well, they were impeached for crimes also. But if they were convicted on any of those non-crimes, let's say if they were acquitted on the crimes and convicted on a non-crime, they would have also been impeached. So that's kind of what has colored my view that Dershowitz's arguments, those that he laid forward, have some real holes.
Yeah, I think the general counter. Oh, sorry, go ahead,
Robert. Okay, you know what? No, do it now, and I'll do it afterwards.
Oh, sure, no problem. So, yeah, just a general sense on that is, part of it is what do we cite for precedents in this context? Because we don't have a conventional, we don't have a legislative process, we don't have a judicial process. We have legislators acting like judges and acting like juries, and often sort of making up the rules as they go along, changing their protocols and procedures from impeachment to impeachment, changing what they define and describe as impeachable from one to the next. And so that's where there's an imperfect and always there's never going to be a certain record like there would be when the Supreme Court said X on this date in this case. And so that's always a weakness, but I see it as a weakness for either side. In other words, just as Dershowitz is limited in what precedential value he can attribute to past impeachment trials, I would say on the side of those of us who argue impeachment needs to be a crime, there's also not great precedential value necessarily in the fact that there have been impeachments of judicial officers without a listed crime, or impeachments including impeachment charges of a president, which did not include a criminal allegation. There's no question the House, if they had their druthers, would impeach for anything they wanted. And I think that's where in the end, I think we end up, there's two different components. One is a textual argument. I think the best argument for impeachment being a crime is the plain language of the Constitution itself, that it uses 4 words, that all 4 words describe criminal conduct, and that was by definition exclusive under statutory construction and language interpretation rules. But I think secondarily, when we go to history, for me, the best history was the Chase trial, because I thought, well, here you have the first real big impeachment trial where both sides have a motivation to make the best possible arguments, where you have a skilled defense and a skilled prosecution team, as opposed to some of the judges who are insane or drunk who never showed up. So it's like, well, who knows? I think the House and the Senate would get away with whatever they could if they could. Why not usurp the power to control the president? I think in Justice Chase, he made a good argument or made on his behalf, also Judge Hopkinson, that why not usurp the power of the judiciary? Because that's what was happening. I mean, Chase's case is an interesting case because there he was sort of usurping the power of the judiciary to politically go after his adversaries. So they were using sedition laws in questionable ways. He was trying people for treason in questionable ways. He was running over due process in questionable ways. But he didn't commit any criminal conduct. It was just whether or not it was an excess of judicial power, what he was doing. Sort of like the presidential impoundment debates that happen with every president. They focused on this one with Trump and Ukraine, but every president since Nixon has faced this. Yeah. They created the statute to stop presidents from doing what Nixon did. Every president wants to do it, so they all do it. But it was more of that kind of debate than he's clearly doing illicit conduct. And for me, that's what was fascinating, was who lined up on Chase's side, the argument. And part of my main argument to the older historical interpretation of impeachment, such as, what did Hamilton mean in Federalist Number 65? What did Madison mean in certain sections? What did Monroe mean in other places? Is that if the Constitution was interpreted as something that didn't have to be a crime based on those texts, we would have seen those texts referenced in the 1805 impeachment trial of Justice Chase. And it was where I disagreed with Dershowitz, was that I thought I agree that the Andrew Johnson precedent is not real clean. You have an unusual predicate. You have some criminal charges, some non-criminal charges. The Justice Curtis's logic was more like criminal-like rather than crime. That's where Dershowitz borrowed it from. And I get why he was looking at, he only considered presidential impeachments of value. And because Justice Curtis was one of the great justices in our history, one of the great legal minds. And Dershowitz wanted to say, here, I'm Curtis. Curtis hated Johnson. Maybe I hate Trump. Maybe I don't, but I'm not on his side politically. And you senators, and I think it was very much, I'll give Dershowitz this credit. He knew who his audience was. So he was not arguing to the country. He was not arguing to history. He was solely arguing to the senators. And he was saying, don't you want to be like this man that John Kennedy put in Profiles in Courage as the great senator, which most of those Profiles in Courage guys end up being guys that maybe took bribes or corruption. Their motivation wasn't what they said. That's just the nature of the animal. And I agree there's not a lot of great precedential value we can attribute to it. It's more the quality of the argument. And fascinating history, just that you have this great legal mind who came down from the bench to defend a guy he despised, is great history. And I think if Dershowitz had been more critical of Trump over the past several years, it would have been more powerful had he made, I think he would have made the exact same presentation. That's who he is. He's very idiosyncratic. He's very confident in his positions. I thought Romney was about to make a persuasive argument about why he thought Dershowitz was wrong and was going to cite to the current Harvard law professor's interpretation of abuse of power, given the way Romney was splitting the baby between the charges. He didn't do any of that. Instead, he was like, oh, I've seen him take it to ridiculous conclusions before. It's like, okay, that just tells me you're not a good legal argument. I don't know how you got through Harvard law.
Is he a lawyer? Oh, he's a lawyer, right?
Yeah, he went to Harvard law. He's talking about how he went to Dershowitz's class, and I was like, this is disappointing. You get much disappointing. Throughout all this entire process, there have been much more informative debates here on this channel and on YouTube and social media about this the constitutional meaning of this important term that, independent of Trump, governs how we look at this going forward. That was the biggest thing to me from educating the public informative, public participation in the little d-democratic process was, are we going to put real limitations on impeachment or not? If we're not, okay, but understand where those consequences flow. Everybody now can be impeached as soon as the opposite party has the House. And I think that was my criticism of the Clinton impeachment. It's like, if we're going to start making personal conduct impeachable, every president could be impeached. There's something in their past that was at least somewhat questionable or controversial. There's no president that avoids that. And the same, and I thought that's where Dershowitz probably was one of more of his effective arguments. I think it comes down in the end. We can debate about the history. We can debate about the plain language of the text. We can debate about who has the power to it. And all of those have good arguments on both sides. It comes down to a policy decision, like what the founders were arguing. Personally, I'm still on the side, and maybe my forebears were on this side, of no impeachment clause at all. And the reason is, I think the tenure of the presidency being 4 years and subject to direct elections, I want the people to have as much direct control over the executive branch as possible. I don't have trust that indirect control through Congress suffices for that, because I don't want a parliamentary democracy. I think in the end, whether they explicitly say it or not, people who are arguing for a broader, looser interpretation of impeachment, in the end, have more confidence in the congressional branches. And the only question I have in that context is, will they still have that confidence if it's of the opposite political persuasion? I think a lot of my friends in the legal academy will reverse their opinions again. And so it's also been embarrassing to the legal academy from my perspective. People are always politically motivated. That's the nature of life. And that's the nature of partisan advocacy. It's going to be that way. But it's been disappointing that the Turleys and the Dershowitzes have been the exception of people who really deeply believe so strongly in the rule of law that they're not reversing themselves in dramatic ways on a range of issues. And I think the legal academy has undermined itself a little bit by being perceived increasingly as just one side of the political equation, so that my conservative friends don't trust what their arguments are. There could have been very good arguments made on the Senate floor, and sadly, they were not on this issue.
Yeah, I definitely, well, two things I definitely agree with. I think the textualist argument is a winner. Like, if we're just talking about the text of the Constitution, you're 100% right. High crimes and misdemeanors, just read the text, But unfortunately, we don't, we don't live in a world where it's just where the text of the Constitution rules, And now I'll just point us back to judicial review. It's not there, or even a whole bunch of stuff that obviously in the 14th Amendment. What is it? I forget the one that they created substantive due process because they read out I forget the clause. They read out from the 14th Amendment. What was it called? Now I forget. I'll remember later. But my point is that the arguments that seem to have been coming down is that impeachment, you can't impeach for crimes, but those arguments were argued in impeachments and failed. In a Pinkerton argument, that was one of the arguments that was made. Impeachment has to be a crime. You shouldn't impeach. And even though he's crazy, he hasn't committed a crime, but yet he was still impeached and convicted. So it's not like this argument hasn't been tested in the political arena, in the actual event, and been rejected by those contemporaries. And even in the delay case, the argument was he's committed no crime, and they impeached him anyway. So I would say if it's just a textual argument about what the Constitution actually says, then I can't argue with that. High crimes and misdemeanors, it means high crimes and misdemeanors. Those are crimes. But if we're talking about the actual application of the law and the interpretation by the people who are empowered to interpret it, then it's a totally different animal. And about the academics, I do agree the academic structure is left-leaning, hard, very much so. I experienced that for myself. You go in there and you say Trump is right, and they kill you. I was a law school lecturer for 2 years, and I've taught everything from family law. And it was one time I forgot what had happened, and I said, well, I think Trump is right on this, and they it was like a landslide upon me, like Trump is right, never right about anything. I was like, hold on, this thing he's right about, he's gonna win, and he won. So. But what I do want to say is that I think for my criticism of Dershowitz, he's the one that has changed his tune. He was the one that was in line with all the academics. Yes, this must be a crime. I mean, it doesn't have to be a crime. Here's the arguments. Here's the precedent. He was saying the same thing I'm saying now. And now I think with Trump, he's saying something different because he says he's more educated. And one of the problems with Dershowitz's argument was that his argument. The citation that he used for his argument, two of the citations, obviously Senator Grimes taking a bribe, that just might have been an oversight. He should, got to talk to his researchers about that. But then the second part of the argument that he cited Professor Bowie, who was one of his colleagues at Harvard, and Professor Bowie was making the distinction that abuse of power is a crime, and if you go into it, Professor Bowie made the argument that abuse of power is a crime, but he was saying it was a common law crime, and it being a common law crime, it could rise to high crimes and misdemeanors, because the argument was when the Constitution was first passed, there was no federal code, so nothing could have been impeachable. But we had these common law crimes, and when these common law crimes were obviously passed and turned into statutes, then it became easier. But there were common law crimes. Bribery, for instance, was a common law crime. Mm-hmm. So his argument wasn't that abuse of power was not an impeachable offense, but it was a common law crime, and that made it an impeachable offense. And mm-hmm. So things like that, bad citations, not telling us the whole story. So it undermined the foundations of the argument. And then when you do just look at the precedent of, the arguments were tested in other impeachments, and the fact that you have the 1993 case with Nixon, where they're saying it's a political question, the court has no role in it. It is not a crazy argument to say that impeachment, as you say, even if I can see the textualist argument that by the text of the Constitution, or the originalist argument that it should be a crime, that the people who interpret it have determined that it's not a crime.
Yeah, I'm not saying it's a crazy argument at all on either side. I think that essentially becomes a policy decision in the end. I think that because you have precedents to both sides, you have a certain degree of poverty of precedents to point to for both sides, that you could take either argument and have a credible claim from history, from precedent, from past, from at least if what I call secondary sources of the material, you have a equal divide on both sides as to what it means. And so while clearly the House has never interpreted impeachment as being limited to a crime and has never said so, by implication, there are arguments that the Senate has in acquitting, but of course, because they're just acquitting, you can interpret different things into what that means. And so I agree that there are limits to the value of the Senate. I think what Dershowitz did is he picked the person that every other senator would like to be like. They want to be written about as a profile in courage in 100 years. And that's why he kept coming back to him. So I thought it was a mistake that almost everyone else made, that was presenting, particularly on the Democratic congressional side, was, I mean, if they're arguing to the country, fine. Okay, then I understand why they did what they did. But otherwise, if they were trying to actually persuade the 5 or 6 senators in there who could flip, who are hostile to Trump, who are either are up for in Democratic seats for re-election like Collins, they would talk to that audience. And Dershowitz basically decided to scratch all audiences except that one. And he knew that those senators, they wouldn't care if that senator really took a bribe. They care about what the fact that senator was written about his profile and courage 100 years later. It's just the nature of those senators. They like to fancy themselves these beacons of integrity and intelligence and honor and greatness. And the Democrats tried to appeal to that at the very end. It was just a little late by that stage. But I think in the end, it comes down, there's the plain text argument, but I think in the end, which side you come down on, given if you look at secondary sources and the split of material in secondary sources. I mean, my argument is always that the 1805 impeachment is the most persuasive secondary source because it's closest to time frame. And I think people who read that impeachment trial transcript, from my perspective, the more persuasive argument is made by those that say, if not indictable, not impeachable. Yeah. But I understand the other argument on the other side. And since 1805, the House and the Senate had clearly not disciplined itself by limiting itself to crimes and subjects of impeachment, at least as to judicial officers and at least on the House side of the impeachment of presidents. The senators have voted to acquit on those charges of the impeachment of the presidents, but you can interpret that in multiple ways, as you know. Yeah. I think it comes down to policy. What do we want? Do we want a parliamentary democracy? If we got to go back and we're sitting in that constitutional convention, how would we write this? How would we want this to be written? How would we want this to be defined? What are our policy concerns? And I think what tends to happen is whoever's on different political sides of the equation tends to interpret impeachment in light of that impeachment. It's the nature of the beast. Of course. And so we've been left with just a small scattering of legal arguments independent of that are looking forward to it. But that's how I've argued it to people that had different opinions on it. It's like, we'll just go back and say, all right, you're in the Constitutional Convention. You don't know who this impeachment's going to be used against in the future. You don't know if it's going to be used against your opponents or used against your allies. What do you want that power to be? How broad a definition do you want it to be? How expansive a scope do you want it to be? Who do you want it to be as a jury? Do you want independent judicial review? Under what context or what circumstances? I mean, like, one of the biggest questions that almost nobody commented on until Roberts answered his question, there have been a few scattering articles, was, what does it mean for the Chief Justice to preside over it? Does he decide rules of evidence? Does he vote? Could he have decided on what high crimes and misdemeanors meant? Did they mean all the way back that they were going to vest the judicial power to a single one official? The next Justice Chase took that opinion in the Andrew Johnson case, but as Justice Roberts noted, he never said so on the record, and he did so on matters of secondary significance. It was amazing how Roberts radically reduced the role of Justice Chase to next to nothing, which was not. It wasn't a surprise given his Rehnquist following, that Rehnquist believed that you should not be involved in impeachment, made that joke famously after the Clinton impeachment. Oh, yeah. I did nothing and did it exceptionally well as to how he presided over the Clinton impeachment. But I think it was an opportunity to have a broader public engagement about constitutional consequences of how we run our government on a day-to-day basis as we see it in application. And unfortunately, the partisan nature of our contemporary politics and legal academy precluded that from happening beyond channels like this. So that's why I think it's good that channels like this, people get to think back and say, okay, do I want Congress to really have the power to remove a president? Or do I think that's more important? Or do I want me to have that ultimate power, the voter, rather than trusting Congress and knowing that there might be a president I don't like who I think is doing terrible things that I could have removed had I broadened and expanded the scope of congressional power? Or will the Congress take out a president I do like, who I think is really just taking on corruption, and the Congress then will become the corrupted body, and they will effectively corrupt the elections by depriving me of my vote, both past and future, by removing someone. I've always been on the little d Democratic side. The more power ordinary people have, the better. I'm not even a big fan of representative government. I like direct democracy as much as possible. So all of my forebears were that way. That's why if you go down to the Constitutional Convention, when it went through Rhode Island, all the Barneses voted no, all 14 of them, because no Bill of Rights had yet attached. and then they sent in the army. And that's when we agreed everything was fine. So so there's always that power. But I think that's the sort of broader scope. And I think for most people watching the debate or thinking about it, basically there are good historical arguments either way when you go to secondary sources. The House and the Senate have, at least the House has never considered impeachment limited to a crime. There's arguments that the Senate has, at least in the presidential context, by their acquittal votes, but that is a vague matter subject to interpretation. The courts have never decided it one way or the other. The legal academy was on one side for one part of the country's history. They're on a different side of the issue now. So they've been on both sides at different times, depending on where you happen to live. The plain text would support a limited construction. The House's application would make it a broad, expansive application. So I think in the end, if you were going back to that constitutional convention, it becomes a policy decision. What you want it to mean now, to the degree that the original textual interpretation is not your beginning and ending spot for those people some people that is, but for those people who are not in that orientation, because there's a lot of parts of constitutional power today that clearly are not in the plain language of the Constitution. A lot of our federal regulation ain't exactly interstate commerce. So don't
get me started with that. Yeah,
exactly.
I'm firmly with you with that.
Completely. So the practical realities on the ground are that people interpret it in a more broad way. How I think it comes down to people's policy choices, and the best way I think I would have interpreted. I mean, I think Dershowitz tried with his shoe on the other foot analogy. I would have gone a little further with it. And he was trying to do it with Hillary Clinton and the rest, but I would have gone, tried to apply it in a different historical context of looking forward. The exercise of your power today is going to impact the use of this power in the future. What do you want that legacy to say? You can make a personal statement about Trump now, and that's one thing. But what you're saying is going to have this precedential impact, just like all the Republicans that voted for Clinton's impeachment guaranteed that this day would come where Trump was impeached by a Democratic House. Had they not done so, I'm not so sure that they move forward, because it didn't have that Nixon level at this juncture. So I told my Republicans friend then they would regret that. They now do. I'll tell my Democratic friends now, I think they'll regret this in 8 years as well. I personally hope we don't get into a place where we just impeach everybody every time that one house flips over. Yeah. Because I think people are the ordinary person, the lay person who doesn't have any, not into this on a day-to-day, they're not on Twitter, they're not following the social media stuff. They're going to think impeachment's just some political tool. And they're going to think it's so limited. Oh, that's just what you do. And the other guy, you don't like the other fellow. Yeah. And I think that's how it's going to be, because they'll experience it through that transitory moment of seeing a few TV articles, news stories, and news articles. And so that's why I think I want the limited interpretation, because I think it protects little d democracy the best. Those who want to have maximum, as they would call it, integrity in government, trust the representative government to be a sufficient check, rather than waiting for the election and the public to make its decision and determination.
Integrity in government. We won't hold our breaths. Okay, let me address some super chats before too far down. Madam Van Kook says, Robert Barnes, in the event that the Democrats keep orchestrating scandals and continues to weaponize impeachment investigations, is there such a thing as malicious prosecution for a president?
This is all fascinating. It's for example, the great thing about Trump is all the different constitutional issues that are now being adjudicated and decided. Yes. Whichever side of the political aisle or legal aisle you're on, you're getting to see them determined in certain contexts. On paper, no. On paper, there's no way to sue Congress for "quote unquote" wrongful impeachment. But I don't think anyone's ever tried it. So so I always say, like, the first case Representative Wesley Snipes in was a civil rights case in New York, where they had issued a DNA subpoena based on a knowing false report of paternity. And they just, the family services people wanted to become famous by going after Snipes. And Wes was one of those people that he's like, no, the government's not coming to take stuff out of my body against my will on a bogus allegation. It ain't happening. So I said, well, why don't we just bring a civil rights suit and say it violates civil rights? Well, nobody's done it before. We end up getting the political ramifications of it led to actually Mike Bloomberg's administration sitting down with me and their chief of staff, who's now at CNN, who's editor of Daily Beast at the time, to get a resolution. So we didn't get a legal resolution. The courts said, no, we don't think you can bring it. Was going up to the Court of Appeals to try to set new precedent. They were worried about the 1 in 10 chance they could lose, and the PR debacle of Bloomberg is misusing the family court system to that's what led to the ultimate resolution, where they did a DNA test on the guy who they knew was the father. Of course, it turned out he was the father, and they apologized to Snipes and all the rest. But I'm always for coming up with creative new challenges. So I do this all the time when people say you probably cannot do that. What I would say in this context is it's highly unlikely that the court system would recognize a malicious prosecution claim, because in the end, we're governed by men, not by the law, as much as we like to be governed by the law. But in theory, put it this way, there is a malicious prosecution when the executive branch brings a wrongful case against you. If a judge brings a wrongful contempt case against you, there generally is not a remedy. Judicial immunity is broad and expansive, unless they do something like, tell the marshal to beat you up in the hall. Yeah. But in the legislative branch right now, I mean, this goes back to the Covington cases. They're interpreting their immunity as broad as the judicial immunity. So it's an open question. Can the legislature be sued if they abuse their impeachment power? There's probably somebody that sued a state government over that, but I know it's never been sued in the federal court system.
But that would start comcoming into sovereign immunity, and also too
all kinds of issues. Yes.
Yeah, I mean, so plus you're talking about suing because impeachment is a political process, and going through, like, I definitely understand what you're saying. You don't want the president just being impeached every day because you just don't like him, and that's right. that is the huge fear, and that's obviously, I think we're coming closer to that. I was for President Clinton's impeachment because, let's just be honest, he was a criminal, and we all knew the Democrats, and the fact that most people don't know, and I was telling Viva the other time, most people don't know President Clinton was disbarred in Arkansas, disbarred in the federal bench, and he had to negotiate with the FBI before leaving office so he didn't go to jail. So President Trump was a criminal, like, no doubt about it. Now Trump, he's not a criminal, okay, in this sense, okay. So I do agree. It's apple and oranges to compare the two. You compare multiple crimes and and negotiating with the FBI versus someone where it's like it's not a crime but it's something different. So I agree they are different contexts, but I believe impeachment is a political process. It's totally in the vein of the political, and it seems like a lot of my friends on the conservative side want to turn it into more of a judicial-like process for fairity, for it to be more fair, for it to be more honorable, for it to be independent. But the founders of the Constitution, if we're going to hold to the contextualist view, rejected that. They wanted the impeachment power to be in this political branch, the legislature. So just in that vein, and even looking back at the Constitutional Convention and all the history, because it's there, and I understand we want to constrain it, but the fact of the matter is that the framers put it there for a reason and left it to the political whims of those two houses. The second thing is about the right to vote. Now, I do understand that I'm one who'd rather have the people decide who their representatives are. I'm someone who's huge with the right to vote and expanding that vote, not to people who aren't citizens, but I do feel that the people should make the best decisions for themselves. That's what America's about. That's what we fought for. But in reality, we're not really directly voting for president. We're voting for electors, and they can vote for whoever they want. And back in when Gore won the popular vote against Bush, there were one elector from the Washington, D.C. area who Washington, D.C. voted heavily for Gore. And that person refrained from voting because they wanted to expose the fact that the votes that those thousands of people, those hundreds of thousands of people just made didn't really matter, and the fact that they needed more representation for Washington, D.C. Now, that was shocking to me because at first I wasn't aware that my vote for president didn't really matter. Was going for somebody else to vote, and they can vote whoever they want. But that's the reality of it. And the framers did that for a reason, because they were afraid of the mob mentality. They were afraid of democracy. They were afraid of, I forget the term, the exact term they used was the tyranny of the majority. And they felt that direct democracy in that way gave rise to the tyranny of majority. And so that's why they formed this Republican form of government, the rule of law versus the rule of the vote. So I do agree, but I think with even direct democracies, there has to be some limitation to that democracy. And I think the founders rightly understood that and put these limitations in there. And now, I am going to say, I do believe that nowadays that, when you vote for president, you are actually voting for a president. But I think, technically, it's just not the case. You're voting for somebody who you hope is going to vote for the person you want. And the last thing is, the argument, I am going to concede the argument for the textualist viewpoint, because again, I agree 100%. I can't even argue against the fact that the word crime doesn't mean crime. It just does. It's funny because I have so many of my colleagues. They want to tell me crime doesn't mean crime. And I'm like, well, listen, come on, you got to at least give me that, what I'm saying? Give me that point. It means crime. The argument's not crazy. But Justice Marshall, I think, I quote him in Marbury v. Madison. We say what the law means, right? The court says what the law means. The words on the page can say one thing, but it's the court who decides what it actually means. And in this case, when it comes to impeachment, when it comes to high crimes, the court has said what the law means. It means whatever the House of Representatives says in that particular context, and it says whatever the Senate says in that context. And I think today that's a powerful thing. Just like the right to vote, how the right to vote has changed from the beginning of our democracy. It didn't mean really anything. You were voting for people. People could only vote if they owned land, and people could only vote for certain people, and they can vote however they want. Now it's a totally different system. So as we evolve to this more, how do I say it? To this more progressive way of thinking about the constitutional interpretation and things of that nature, it's true that high crimes and misdemeanors should be constrained so we can have some consistency with government. But as a legal matter, I think the argument to say that it is this way is just not there. And I think Dershowitz's argument that it should be interpreted that way, it's compelling. But the fact is, it's not. And that's the argument.
All right. And hold on, before we go there, just going to do Jason L. I love you three, even though I disagree with each of you on different. I understand it's blasphemy to like someone you disagree with in 2020. That's okay. I'm already going to hell. Thank you, Kappa. Okay. And then there were just a couple more. We got mandatory carry, hashtag keep fighting. Thank you very much, mandatory. I got a question coming up in a second. We got dog eat dog, which is not coming up. Why label it crime and not breach delinquency? Okay, well, I think we've indirectly addressed that particular question, but I do have one specific question that I want to get to right after this one. Leif. No, it's pronounced Life.
Leaf.
Not Leaf.
Life.
Radio, my name is pronounced Life, not Leaf. Got my last name correct. Last name is Sandiger. Thank you very much, Life. And then I think I missed one more, which I'm going to get to before I totally forget. Give me 1 second, because I'm going to not sleep well if I don't get it. There was one before Madam Von Kook. Joe Ward. When is it time to stop looking for a precedent? This law does not seem appropriate for this day and time. Maybe it's time to rewrite it and be more specific. TDS does not leave room for interpretation. Okay. I guess we'll get to one question afterwards. What would it take to rewrite this or to clarify it in a constitutional sense? But what of the argument that someone raised in the comment section a while back that judicial impeachments are different than presidential impeachments because judicial appointments are for life, whereas presidential appointments are for a maximum of 8 years, but renewable every 4 years, so to speak. So that the criteria that would apply to a judicial impeachment would almost be more lax, hence potentially admitting of non-criminal activity because they're appointed for life and are not susceptible of removal by general election every 4 years.
It's funny because now I'm going to go into the heavy textualist argument, and I'm assuming Robert's going to go into the more progressive argument, because my thing is going to be, well, the text of the Constitution doesn't really give you that distinction. The only distinction it gives you between the two officers is really that if it's the president, then it's the Chief Justice who presides. But really, there's no textual argument that can be made that the impeachment standard should be different for the president, even the vice president. If the vice president is impeached, it's going to be under the same standard. So I do understand that judges serve for life based on not good tenure, but good behavior. But if we're going to look at it as a more textualist view, then there is no real distinction except who presides over the Senate trial.
Well, now,
yeah, I was going to say, yeah, the same thing on that. Because my view is that the only reason why we had impeachments for things that were not a crime for judges in the past was because the judicial branch had not set up an internal self-regulatory mechanism for judges who were just literally not able to perform the tasks that they were doing. So I think had we had that, like what was one interesting, like in Pickering's case, they avoided, they voted convict, but they didn't clear up what they were convicting him for. So because they were nervous about what exactly the consequences of that were, they're like, well, is impeachment power supposed to be for this? And I think if they had done their job, they would have not convicted him. And that would have forced the judiciary to much earlier adopt internal self-regulatory mechanisms to solve that particular problem.
That's a very good point.
But the questioner is right that there's a different policy at issue. I don't think it impacts the interpretation. I agree with Nate on that. But there's a different the elections are a check on the president in a way they're not a check on a judge. The flip side of that is judges have much less power than a president does. And so I think those counterbalance each other, if you will, from a policy perspective.
But to push back on that, I mean, first of all, I'll push back on both of you because, Nate, on the one hand, you're saying we don't adhere to a strict reading of the letter of the law when it comes to high crimes and misdemeanors, but we adhere to a strict reading of the letter of the law when it comes to not drawing a distinction between judges and presidents, which is an incongruous argument to hold at the same time. But so setting that aside, Robert, when it comes to impeaching a judge for a non-crime, they're still subject to the incapacity provisions of the Constitution, right? So if they're just unable to do their job for reasons of insanity, alcoholism, or whatever, in theory, they wouldn't need to be impeached under, I don't want to mistake whatever provision it is, but under high crimes and misdemeanors, they would be removed from office for inability to do their job under the other provisions of the Constitution, right?
Well, there's suspensions and life 10 years of issues that get into good behavior. And that's sort of where that gets to. But it wasn't clear what the remedy was. And that's why impeachment was used early on to deal with this problem. It's fascinating they didn't anticipate it. Because I mean, you're going to have more judges than you're going to have presidents just by number. And I can't believe that the British judges were also, there were no drunks or nut jobs amongst them. I'm not buying that. So it's intriguing that they just flat out didn't anticipate it. But I think the other part of this is impeachment was a late addition. When they were building up the Constitution, they weren't even thinking about it. There were some very strong minds opposed to it. And they had to overcome that. And then they left it as being the sole solution for that's why the 25th Amendment had to be added much later. They really didn't have a problem for president. What you're talking about is presidential incapacity. They added that, the 25th Amendment. They wouldn't. Now, that's an argument that people like Dershowitz, he didn't make it, but he could have made, which was the structure of the Constitution with the addition of the 25th Amendment shows that impeachment's meant for crimes. Anything else is really the 25th Amendment.
And that's the most powerful argument I think he could have made, because that's a very convincing argument. I'm sorry to cut you off, but
they were good at there were a bunch of us trying to get info to Dershowitz. He had self-isolated himself, so he got some of the early stuff about Curtis and whatnot, but that was 6 months ago. It shocked me all the way back, just that the Legal Academy had not treated this as a straightforward debate. And unfortunately, and they just sort of presumed things. And I think that's why we saw what we saw on the Senate floor. We saw Dershowitz, who's a recent convert to this position. So he isn't as fully vetted in the issues either. And you see, I thought as someone, he did as good a job for where he was at as could be done. I thought a much better, fuller argument could have been made.
I think the argument you just made would have it's a showstopper, because you're right. That's the reason why they passed the 25th Amendment, to have that provision. Go ahead, Viva. I'm sorry.
Yeah, just going to say, the 25th Amendment, for the ignorance out there like myself, that is only presidential incapacity, or is that any official incapacity?
I believe it's just president or
It's
vice
presidential.
president.
Yeah, president.
Yeah, there may be a vice president subcomponent in there somewhere.
So
You know what? Because I made this argument in a civil rights case as to why the Peace and Freedom Party, who is a 34-year-old candidate, AOC would fit into this category, and she run for president. I was willing to sue on behalf of AOC as well, because my argument was the 25th Amendment anticipated someone also getting elected who did not qualify because of age. And what would happen is the public could choose to elect that person knowing that the vice president would be president until that person came of age, because it actually has this detailed structure for that. So it was dealing with another particular, it seemed like they were expanding the franchise to make it more powerful for voters to pick, while at the same time dealing with someone who may become completely incapacitated, so that you don't have, what's the famous joke? That guy that ran around saying he was president after he was secretary of, I think it was Nixon or
somebody, acting president,
or maybe it was Ford. It was maybe when Ford was like briefly incapacitated or something.
No, you're talking about Bush, when Bush had the colonoscopy and he was incapacitated.
Yes,
and they triggered the 25th Amendment to let Cheney be acting president. He wasn't president; he was acting president.
Well, there's that. There was an earlier one where Alexander Haig.
Yes,
don't worry, I'm in control. I'm running everything here, which terrified everybody. So it was like, this is counterproductive altogether. But it is a good point that they're making, that there is an election check on the presidency in a way there isn't on judicial officials. But I don't think that should change how high crimes and misdemeanors are interpreted, because for me, I'm a textualist. So someone has to give me overwhelming reason to show that the text isn't applicable. I mean, I, for example, don't agree with the Marbury versus Matta decision that the Supreme Court is the ultimate decision maker on what is and is not in the Constitution. No. Everybody takes the oath to the Constitution. So they all have the same obligation. They all have the same power of interpretation. And a part of me is sympathetic with Andrew Jackson's famous statement to the Supreme Court. Well, they've made their ruling. Now they can go enforce it.
That was the first true challenge to judicial review. It was like, no.
That really the only one.
You can't do it. That's true. Yeah.
We've had subtle subversive attempts at it.
That's true.
But one of the few overt, blunt, straightforward. It'd be a Trumpian kind of thing to do, but even Trump hasn't had the guts to do that.
No, that's something I think everybody would get behind an impeachment for. But I think Andrew Jackson, don't forget, he was phenomenal. You couldn't do anything with him. Yeah, you couldn't do anything with him.
He's from Tennessee, so he could do no wrong.
Did he want to kill his vice president one time?
I'm sure that's true.
Yeah, he's tried to.
Yeah, the thing. I mean, to his in his defense, he blamed the prior candidates against him for killing his wife, for his young wife dying early. The nastiness of that campaign. So he was a bitter guy, and a rough guy, just like Andrew Johnson was. Yeah. I mean, for Andrew Johnson, for all his problems, I mean, if you had been a previous slave owner, the only way you could get any of your land back is he required you to crawl on your knees across the floor and beg him. So Andrew Johnson came from East Tennessee. So that's why he wasn't embracing Northern Reconstruction, but also was very anti-slavery, because he came from that part of Tennessee that hated the planter class and didn't like the Northern industrial class either. And he got caught in the middle of it, of course, and it led to his impeachment. But just something about that mental streak, mind streak, different dynamic. But I think these constitutional questions are questions that unfortunately were not as debated as well as they could have been on the Senate floor.
And fun fact to the chat, just real quick, and the law that Andrew Johnson was charged with violating in his impeachment was found unconstitutional later.
And that was one of the key issues that Curtis was arguing. So Curtis was saying it's not indictable if it's not impeachable, if it's criminal-like. And his point was this law really needed to be a clear criminal law from before him being president, not some new law you made up just to call it just a crime to get him at the time. It was so obvious.
It was very interesting. Go ahead, Viva. I'm sorry.
No. I have a few questions. I just want to get to them. Both of you have referred to previous impeachments that included articles of impeachment based on abuse of power. The question I have, I think I asked it, I'm not sure if I ever got an answer, but has there ever been a standalone abuse of power that was not itself coupled with another article of impeachment that was itself a crime? And because Nate, you mentioned it earlier, like, okay, fine. In theory, you can get condemned on any one of the multiple articles of impeachment. So if one is abuse of power, the 7 criminal articles can fail, but you can still get impeached on an article of abuse of power. And then my argument or my question was, has there ever been anyone who was impeached on an abuse of power charge that was not itself coupled with an actual criminal charge?
from a presidential perspective, not in the case of either Clinton or Nixon, but Johnson, I think count 10 or 11 was just a straight abuse of power charge.
Well,
Now it was tied to the theory that the reason it was a lot like Trump's. It was a motivation charge. It was his reason for not following the Office of Tenure Act that we passed to limit his ability to control Reconstruction effectively in his cabinet. Yeah. His motivation was bad. His motivation was to misuse his power, to undermine the legislative branch, to have the executive dominate over the legislative branch, and so forth. So I think it's people look it up, they can find it, Andrew Johnson. I think it's count 10 or 11, if I vaguely remember.
Well, count 10 is for disrespecting Congress. So I think
yeah,
count 11. Yeah. That's literally what it was.
Yes, exactly. So and that was sort of parallel there to it. So the argument for the side that says impeachment doesn't need to be a crime is that the House did in fact impeach on those grounds. The argument for the idea that impeachment does have to be a crime is that was one of the counts that they acquitted on in the Senate, with the vagaries of you never know what their motivation was. So it's similar. The how the Senate process works, and this is also interesting to me. It's not at all clear that the Senate's supposed to be just a jury. There's an argument out there constitutionally that they're actually like a judge operating a bench trial, where there's a lot of trials in the United States that aren't jury trials, that are bench trials, judge trials. Mm-hmm. And there's an argument the Senate is both. And this argument is actually what the argument that Roberts was implicitly making when saying he couldn't have a vote about even evidentiary issues.
Well, hold on. Quick question. Wasn't that Rehnquist in the Clinton? Remember in the Clinton impeachment?
Yeah.
They called them jurors, and he said, no, these aren't jurors. They're
Correct.
Senators, and you got to call them judges. Wasn't that the argument that they're not?
That's exactly right.
All right.
So we have both Rehnquist and Roberts have the opinion that the Senate is actually acting as a high court of impeachment, and they're all individual judges and it just happens to be 100 judges rather than one. But in that context, because one of the ways it would matter is when you acquit as a jury, you never have to give your explanation. Sometimes you do, but it's not considered binding or determinative in any manner what your reasoning was, unless something impermissible came up that they disclosed. And then occasionally the court can get into that, but often jury deliberations are considered off the table. You can't get into what happened in the jury room. Well, but that's not like a bench trial. Frequently in bench trials, judges are supposed to give the bases for their decision. And the irony is that they've never required that of the Senate. So like one of the things here I wish they would do in the impeachment process is say, hey, make every senator explain on the record their vote. Now here they kind of did that with their verbal speeches, but I would have liked almost like a jury, like sometimes you have what's called a special verdict these days in juries. And so you have sometimes they're ridiculous. They ask juries to answer 400 questions as if they're law students. But the more reasonable ones will have like 10 questions or 12 questions. And the jury, and it would be nice here to say, is this a crime? Make every senator vote on it. So at least then we don't have to guess 50 years from now what they meant when they voted for acquittal. Did they mean Dershowitz was right? Did they mean they disagreed with Dershowitz, but they had a different opinion? Did they mean they had a even more limited definition than Dershowitz had? Or do they think Dershowitz was just all off? We'll never know. We don't get to argue from precedents other than arguing, hey, Dershowitz argued on the Senate floor. And so I like those arguments. I'm glad Dershowitz made them. I'm glad that the people made them back in 1805. I'm glad Curtis made them. But it's unfortunate we end up with very vague interpretations. From a secondary source application of the law, we end up with very vague interpretations. And going to Nate's point that the law is really about power, what people have, who has the power to do something, and who has that power is what we ultimately have to respect. We don't get the precedence of power. We don't get to say how they exercised this power in the past to guide us moving forward as to how it's likely to be applied in the future. It's just an unfortunate weakness of the system.
Okay, it's very interesting. I'm going to clear these two super chats, and then we're going to get it. Okay, Jason L. off topic, but hopefully y'all can confirm time. You can find time to address it. It's my view that the popular vote pact is unconstitutional. You can't just find clever ways to sidestep the Constitution. Am I wrong? You both can feel. I don't
big open debate. Another completely untested issue. Completely The Supreme Court will be taking up Nate's earlier point. They're going to be taking up whether the faithless elector issue.
Yeah.
So that'll be interesting. That'll be fascinating because I remember debating that at the time. So maybe in that context, they'll give us some guidance about what can states do or not do. My guess is they'll skip it, but it affords them the opportunity to at least give some generic dictum type language that at least gives us a sense of direction about how flexible is a state. Because in Bush v. Gore, they said the due process clause limits how a state decides to award its electors once it issues certain guidelines, if you will, to the voting public as to how they're going to do that. That's how they got to that point.
But didn't Scalia make the point in Bush v. Gore that that the American citizens didn't have the fundamental right to vote?
Oh, yes, he did. And he was happy to make that point. It's another point where I disagree with Scalia. I mean, I agree with Scalia about 2/3 of the time. I had a debate with him when I was in college. I'd invited him to participate in the Yale Political Union summer participation program and cited his involvement in the spring Yale Political Union program. He misinterpreted the letter as saying he had already committed to the summer program. So he actually wrote me a rather nasty note that said, "Hey, well, I was going to commit, but now I see you've already committed me, so the answer is no." And I wrote back and I said, "I hope you read letters better than the Constitution, because that's not what I said." So he got
so jiffy. How did you jiffy with Scalia?
It was back and forth, and I had great respect for Scalia, and I met him later, and it was all good fun and all good laughs. But it was no question that that's what that decision meant, that there was no clear direct right to vote. I think there should be a constitution. So going to this popular pact idea, it's an open question whether it's constitutional. Well, what I would rather have is some constitutional amendment if we're going to try to replace the Electoral College, rather than each state trying to find a way to change how it does electors. For example, this is the most analogous area context this comes in is tax. A whole bunch of states borrow the federal tax system and incorporate it into their state legislature, which has always been insane to me. It's like, hold on a second. So if I'm in California, what tax I pay is actually up to what some congressman for Delaware passed last year. Why should my California tax be based on what a Delaware congressman wants in the tax legislation or what some federal regulation recently passed? But they've generally allowed that kind of pact, if you will, to exist, where you borrow from, where you can live off of what other states or the feds are doing and incorporate it into your own law, even though it didn't pass through your regular legislative chambers. But I think if it went up, it'd be controversial one way or the other. It's a close call. I don't like it personally. I think let's use the amendment process, not let's have the states get together and try to get around it. So instinctively, I would prefer that it not be considered constitutional, but it's far from clear precedent that it would be, because it's old debate. How much power do the states have? How much constitutional constraint is on that power when it impacts the election to the presidency? And Bush v. Gore is about the only case to actually try to step in, and there they were vague, obscure, and all over the place.
Because they didn't want to get involved in it.
Exactly.
First, I want to say with Scalia, two of my favorite justices is Scalia and Thomas. And well, my favorite is obviously Ruth Bader Ginsburg, but two of my other favorites are, and most people don't know this, Ruth Bader and Scalia were closest friends as possible.
Scalia was a good guy, and a brilliant mind, cantankerous but a brilliant mind.
Well, one of the best decision I've ever read from Scalia is the VMI dissent. Beautiful. Beautiful, well written. It should have been the majority, because the argument he made in that was outstanding. Even the liberals who taught me in law school say the VMI dissent is amazing. If you guys have a chance to read it, go read it. It is amazing. But in this, I think from the question that was asked, it really deals with the faithless electors, because the argument for that side was that since the electors themselves are faithless, where the votes of the people actually don't matter, then we can just give, the state, if the state then by rule just says, okay, whoever wins the popular vote gets it, then that kind of drops into that faithless electors. And it's kind of a slap in the face to democracy that, hey, you can have a state where 95% of the people voted for the other guy, but that state's electors, because they're faithless, are going to go to the candidate who won the popular vote. I think it's a travesty. I think, it's insane that people actually even thought about this, but hopefully it'll be tested in the courts and it'll fail, because it is a travesty.
Yeah.
Okay, very interesting. Okay, hold on. I'll get to this one. Y'all see the story today. Trump is hesitant to sign a bill funding aid to Puerto Rico due to funding structures within that seem like a setup. Hot stuck. Very interesting. I
got to look it up.
He's going to be hyper paranoid about all of this moving forward.
Of course, he's got to be.
He thought he had broad flexibility. He now recognizes he doesn't. Romney's vote reinforces that. I think Romney's doing what he's doing but if Romney's purpose was to try to discipline Trump, it's going to have the counter effect. Trump is now going to be paranoid of the entire administrative state, and everything Congress passes when it involves funding of almost any kind that has any discretionary component to it in terms of timing, in terms of location, in terms of how it's spent, in terms of who it's spent through. He's going to think they're all out to get him. I don't think he's at, Nixon talking to paintings level, walking around the White House. But but I think his level of cynicism about the system will have dramatically deepened by this experience. People who had studied populist, this is my argument with Steve Bannon, would have known this was coming. Almost every populist type figure, left or right, has either been impeached, investigated, or indicted. Yeah. Huey Long almost, Huey Long was probably a potential analogous example for Trump. Huey Long, they tried to impeach him. He got 13 secret votes to back him, that they signed an oath to defend him. Nobody knew about it. So they voted for his acquittal. And after that, he said, I used to try to work with everybody. Now I just try to crush everybody. And it just changed his demeanor and disposition. So I don't think Trump will get that bad, but I in terms of reaction, but I think he will become hyper skeptical of a lot of things that he previously just sort of didn't even take a second look at.
Okay, very interesting. This is going to get into a second question that I have. Will D, could a future House repeal the impeachment resolution? I don't know the answer to that question, but my follow-up question would be, and I think I know the answer, but in theory, could they impeach a former president who's no longer in office?
Well, hold on. Let me answer that first one. Yes, they can, but it's an impeachment against because they get salary and they get security and all that. So it's like for I forgot who was it for? I forgot what president. What it was for Bush? Yeah, there was like talk of impeaching President Bush for war crimes or something like that, and he was out of office. So they were saying, well, can you impeach him? And they said, yeah, you can impeach him, but it just takes away all this protection and all that stuff. He would simply just be a private citizen. But I think that would be ridiculous. If the guy's out of office, leave him alone. Give him his protection, protect his family.
It depends how vengeful you want to get in terms of partisan politics.
Like no matter how bad he is, if the guy's out of office, he needs protection for his family. Let's not go too far with this. But the second thing is about the second question was about the impeachment. Can you repeal an impeachment? I don't think you can. I think it's impossible. But there's some history with this. Some precedent. Andrew Jackson, who's on the $20 bill, he was censured by Congress, and then when the new Congress came in, they erased it from the records like it never existed. So maybe a future Congress can do something like that, but they just erased it from the record. Go ahead, Robert. I'm sorry.
Yeah, no problem. Yeah, my own take is from a constitutional perspective. I think only elected officials should be impeached, and I think once an impeachment happens, it's like an indictment. It always exists. You could expunge it. Maybe is the argument. But if you were to make that analogy, now. But the flip side is from the argument that whatever the House says their impeachment power is, at least as a practical matter, becomes their impeachment power. From that side of the equation, could a House come in and say, we hereby expunge the impeachment of Donald Trump and say it was a wrongful impeachment? Yeah, there's nothing that stops them from doing that. No. So what does it mean? Open question, because it's never been presented before. It would probably only matter in a removal context. So in other words, I don't think this issue has ever maybe came up once. There is a congressman who was impeached while he was a judge. He sits in the House now. What's his? I can't remember his name. He was from Florida. And I remember at the time they decided not to remove him, but there was an open question was if the Senate voted, because you can remove the person, but not ban him.
Not disqualify them, yeah.
Yeah, disqualify. They can remove and not disqualify, or remove and disqualify. It's not a necessary combination they have to do. There was an argument about whether or not they could reverse disqualification. So in a subsequent Senate. And there was some implication that, yes, they could. Again, it's something that's completely undecided. I'm disinclined to give them that expansive power to undo what a prior Congress had done. But from a practical perspective, following Nate's argument, there's not much one could do if they actually did it. No. And the only way you would really test it is if someone they had disqualified, they then turn around and requalify. An analogous example of this, in a totally different context, but somewhat comparable, was in Wisconsin in the 1930s. A lawyer got disbarred by the Supreme Court. He decided the Supreme Court didn't have the power of disbarment. So he went back to the legislature and said, legislature, I want you to declare me licensed to practice. And the legislature did, because he was well politically tied. It went back to the court, and of course, the court decided that didn't matter. He's still disqualified. But it was an open, and because the court controlled where he practiced, it mattered. But if it didn't, it might not have mattered. What if he was a mechanic, say, rather than a lawyer? Then the court's ruling might not have been enforced by the executive branch because the legislative branch had a different interpretation. So it's an unresolved issue. Is the long and short of it. My own view is to limit the power in general, so I'm not in favor of expanding it. But as a practical matter, there's not much one could do if they choose to exercise that expanded power.
And just to be clear, I agree with you. I think government powers should be constrained tremendously. I think this right now. I think like the administrative state and everything. It's way too broad. We're out of control. Right. I think Reagan was right. It's time to start getting government out of people's lives and constraining the power of the government. I'm sorry. I just wanted to make sure everybody's clear that that is my position too.
I was going to say someone in Jason L in the comment section said it was Hastings, Robert, who you might.
Oh yeah. Yes. Alcee Hastings. I'm
hesitant to bring up the comment only because of the language, but I do want to ask a question on Mitt Romney's speech today for anybody who saw it. It was horse poop, deeply religious, whatever. Okay, fine. He couldn't vote in good conscience vote otherwise.
No, that's how he described it.
Yeah,
he said both his religious motivation and so there's now memes. Babylon B has a meme out there that said, founder of Joseph Smith says personal character is critical to one's search. So I'll let people make their own interpretations about that. I'm making no comment whatsoever. But I see where their point is. I don't think anybody who knows Romney. Here's the thing. Let's say my motivation was what Romney's motivation was. There was a way he could have explained his vote that would have been persuasive, that people would have been like, I disagree with him, but I think he made that vote based on independent act of conscience. The people who are opposed to Trump are always going to like his vote. It was really, could he persuade people that had voted him in office? Whether, okay, I disagree with him, but he's just being an independent person. That's who he is. I thought he didn't, he talked. It's like what I do. Whenever somebody tells you that, hey, you can always trust me, I'm really trustful. I'm always immediately distrustful because someone who's trustworthy doesn't have to keep telling me over and over again, don't worry, I'm trustful. So it's like that. That's how I'm sympathetic with the commentator's question or the questioner's comment that it came across as unpersuasive and a little moralistic. In other words, it came across like, hey, all you Trump supporters that think I shouldn't vote this way, that's because you have less of a conscience and less of a religious belief than I do. That's how they interpreted it. And he could have avoided all of that by simply not doing this. I'm doing this because conscience calls upon me. He could have just, if it was not politically, personally motivated, or even if it was, if he wanted to present it otherwise, he could have said, look, here's why I think this is consequential for the country. Here's why I can't go along with it. Here's why I think we have to send a message for future presidents. If he had said it in that way, people would have still disagreed with him strongly, but they would have been less. Hold on a second. You're telling me I'm less moral and I have less of a conscience because I have a different opinion than you, Mr. Romney, on Trump and impeachment. But it's Mitt Romney. There's a reason why I bet against that guy every time I could in 2012. He gave me a lot of money, so I can't. I'm never too much. It's like Nate Silver. I can't really begrudge him too much. They both made me a lot of cash. I was like, man, I was looking forward to a great impeachment debate and argument. There were bits of that in the '98 impeachment debate. Mm-hmm. There were bits of that when you read the history from 1805 and 1868. I didn't think we got a lot of great moments on the floor, to be honest. I was mostly disappointed in the presentation, and particularly in the senators. You had 10 minutes to really make your point, and whose points are we going to remember even tomorrow? Least of all, 20 years from now.
Well, that's the standout in this was Dershowitz. Dershowitz.
Yes, yeah, I agree.
Dershowitz. No matter how you feel about the person, his performance was probably the best. And also Schiff. I think if you go about a close second, Schiff, because Schiff was trying to pull on the heartstrings. He was all emotional. So if you think who did performances.
Schiff might be memorable for another reason. I don't know if it's going to be for the same reasons as Dershowitz, but when it came to Mitt Romney, and I've said a few things repeatedly in previous videos, like when anybody invokes their good, their morality, when anyone invokes religion, when anyone invokes their kids or their grandkids, I immediately get suspicious of the basis of their argument. But when Mitt Romney said in his speech, Mitt Romney, as far as I'm concerned, in his discussion, fell victim to this false dichotomy that it was either in the national interest or in Trump's personal interest, as though the two couldn't overlap to otherwise exonerate what Mitt Romney convicted on. And when Mitt Romney said, in respect of Biden, is it illegal to ignore conflict of interest? Is it a crime? No, but it's definitely wrong. Well, as if to say then that Trump was guilty and should be convicted for wanting to have investigated something which Mitt Romney just said was not a crime. But ignoring a conflict of interest is a crime. And then in his own setup, it seems that he undermined the very argument and almost exonerated Trump in his conviction by saying, if it were a crime, then it would have been legitimate for Trump to investigate, but ignoring a conflict of interest is not a crime, whereas in reality it is. And so he was just not sucking and blowing, but he just wanted to get to a conviction and wanted to write off all of the evidence that he didn't like, that didn't support his position, to get to the conviction. But I think he really contradicted himself on that. And then to get to the point where it's either in Trump's personal interest or in the national interest, as though the two can't overlap. And if they do overlap, which one takes precedence when you're trying to convict someone on impeachment? But
especially if you were out there to be Romney, the way to do it would have been to take a much more proactive role in questioning. Yes. For one thing, and set it up so you can show people, I have this very serious concern. You need to address this serious concern. Here's where it's coming from, and things like that. If he cited that statute and so forth, then that could have been exposed to debate and discussion, further commentary on social media. In other words, and he might have recognized, oh, my assumptions are erroneous or my application doesn't make sense. That's the other thing that made this all sound like bad grandstanding. He had not set this up for his position. He had not shown, the kind of interest, someone who was truly a tortured soul, like, the good senator from West Virginia. I get it. The tortured soul. Well, then ask more than one question of the people during the process. All right. Then you'll sell me that it's a tortured soul. These are people who don't even know how to be good presenters. It's like they all need to go to. It's amazing. These are our leading politicians in the country. Now you see why Trump went right through them during the Republican primaries. It was like I just crushed him. I mean, just like like it was a sword through wheat. It's because these people are terrible. Like when I was watching them, I was like, there's almost none of these people I would pick to advocate for me in any court, anywhere, any place, and yet they are our leading public officials.
No, it's a very legitimate point that I actually had not yet thought of up until now, is that anybody raising these deep core troubling conflicts that they didn't want to do it went against everything they believed in, but they have to do it out of the goodness of their heart and their conscience. Yeah, if they didn't sit there grilling and asking the questions that would quell their deep-rooted concerns, it's almost superficial to pretend now that they were deeply disturbed by things that they never bothered to ask questions on in the process.
Well, I to be honest with you, I like Mitt Romney's speech, and I felt it was two things. Number one, these are political people, and they're not making speeches for the academics or even for the others. They're making for their voters and for the people who are backing them. And I thought that's what Mitt Romney's speech was. People in Utah, are pretty. Remember, they had for the primary, they had a third party candidate who was doing better than Trump. So they're not Trump fans in Utah. So if you think about where he's coming from, the political allegiance, he was politically able to do this with no real consequences. Because they're going to vote for him. So this wasn't some profiling courage. This was a junior senator knowing that the state I'm in don't really like Trump. And I'm going to be okay, so I can do this. So I also thought that one thing about Romney, which convinced me that it was decent, and that he was correct, was that I think the argument that I do think the argument that if it was the other side, if Obama had done what Trump did with Ukraine, I would have argued that he should be impeached too. And if you can look at it that way, then I fairly should say he at least had the courage to say, yes, okay, I disagree with my own party. But that was a political calculation. I don't think that was of consciousness of guilt. I think it was just, okay, the politics, I'm safe. Where like Lisa Murkowski can't do that because, they'd vote her out of office.
Do you know what the funny thing is? I mean, and now that you mentioned that, and it brings me back to 4 years, say it would be like 8 years ago now when I was politically ignorant. When you say, had it been Obama in Trump's shoes, I'd vote to impeach or whatever. Given the scandals that occurred during the Obama administration, had I even thought that impeachment was a legitimate or even a plausible remedy, had the world been in this framework now, I think a lot of people would say, yeah, let's jump to impeachment on the Fast and the Furious. Let's jump to impeachment on the Iran non-paying off for hostages deal. Let's rush to impeachment for the IRS targeting the Tea Party. No one even thought that these were legitimate remedies then, and now the framework is so different that I have trouble conceiving of if it were Obama now, because when it was Obama 8 years ago, no one, including myself, even thought that impeachment would be the appropriate remedy to deal with those things.
And when I think there was some discussion on the Republican and conservative side during that time period, particularly the second term of Obama. But my general view was, and I think this was wise politically, you've seen Trump generally avoid attacking Obama. He talks about Hillary and the Clintons far more than Obama. When you're talking about the first ever African-American president, to try to take him out in any way other than an election would have angered large numbers of people across the country in ways that would have been impossible to get past. Yeah. So I think, but that's where I think that Obama immunity. Also, Obama was one of the most well-liked individuals. That was always fascinating with Obama. Personal approval high, job approval low. He was reverse of Trump. And so Trump, a lot of people are uncomfortable with Trump, the person, like the job Trump has done. So, his job approval, and the more specific issue that you get to an issue, the more his job approval goes up. The more generic and the more closer to Trump, the person you get, people are uncomfortable saying, I approve. Whereas Obama was the reverse of that process. The more specific issue you got, the lower his job approval went. The more you talked about Obama, the man, the more people liked him. But I don't think that immunity will extend to any future presidents. I think, especially, I had been hopeful that if somebody took a noble stand and did it in a really effective way, that this could have been a persuasive opportunity to say impeachment, bad idea. Let's not move forward on this moving forward. Let's limit the scope of this moving forward. Whatever their reasoning may have been, that did not happen. So because that did not happen, I think impeachments are now part of the parlance of American politics. So it'll be whoever gets elected. Whenever the House is in the opposite party of the president, there'll be massive pressure now to impeach. Yeah. And I mean, that's what I mean. Like Pelosi, I think, didn't even really want to move forward this quickly, but felt obligated by her base. And a Republican will be no more immune. And especially we're in a political era that's like Sean Trendy, a buddy of mine who writes for Real Clear Politics and some other places. He's got like 7 degrees. He's one of those people, PhD, JD, this. He get a great analogy that we're a lot like the late 19th century, post-Civil War era. So it's interesting that Andrew Johnson impeached then, Trump impeached now, but that back then partisan, each side would wave the bloody shirt of the other side. And ever since then, they've called certain social issues waving the bloody shirt, because you would wave the bloody shirt of the Union Army or wave the bloody shirt of the Confederate Army. And that it was so intense, you had incredibly partisan era from about 1867 to really about 1905, 1906. If we continue to have that deep of a divide in the country, then you can almost guarantee that impeachment is now a card that you almost have to play if you're the party in opposition to the president moving forward. It'll just be what issue they pick. I think at least some Republicans, what bothered me was only a few Republicans publicly embraced the crime limitation. And when they were doing it, I was like, well, the reason they're doing that is so they get to bring a non-crime charge down the road or vote convict down the road. So I did not like that at all. That was very unfortunate, and that's a telltale sign. So if there were betting odds, I would bet that whenever there's a House opposite to the president, I would immediately bet, yes, there will be an impeachment within a year of that being the case. Moving forward,
I would take that bet. I'm saying I would. Yeah, I agree with that. If somebody was to bet me, I would say, within the first year, it's more than likely going to happen.
Okay, Jason L says, Romney, should he be independent? Shouldn't he vote how his constituents want, not how he wants?
That would be my view, but that's my little D-Democratic view. That's why I'm not a big fan of representative government at this type. It is true that's what our founders created. And so I agree that from a constitutional perspective, he was specifically given the power to vote independent of the voters. The voters have a check on him at re-election, but that's it. And his politically persuasive effect might be impacted in the national electorate based on what decisions he makes now. But the Constitution gives him the power to vote however he wants and doesn't put any restriction on that other than he can't do it for a bribe. And he can't do it for treason. But beyond that's it. Though, by the way, senators have argued that the speech and immunity clause, like Senator Warren is arguing in the Covington case, that it actually immunized them from bribery as long as the bribery took place on the Senate floor. Yeah, it actually went to the U.S. Supreme Court. They're like, no, this bribery happened here. That's okay. You can't do anything about that.
Oh my God!
So it's an interesting thing about it. So I think Nate's right. The Constitution makes Romney an independent actor whose future limited by the public. They can reject him at re-election. My own view is I would prefer a system that had as much direct democracy as possible. I'm on that little p populist side of the aisle. And have always been, and I'm a little more of a little d Democrat, just like my forebears were. I mean, they wanted the Bill of Rights in there. Now that was an individual rights issue, but they were of the same political stream of thought that was opposed to even having an impeachment clause, for example, and was for direct elections of officers from day one.
Hey, Robert, if I may just ask you a quick question.
Sure.
What do you think that there's a movement going on now in academia about the one man, one vote problem when it comes to the Electoral College? And what happens is that if you live in California, it's like one vote in California. Actually, let me make sure I'm very clear. 6 votes in California equals like 1 vote in Wyoming. Right. So there's now a movement going to say that that's a violation of the principle of one man, one vote. If I move to Wyoming, my vote is more powerful than if I move to California, So the argument on one side is saying that it's a violation of one man, one vote. And the argument on the other side is that it's a constitutional restraint. These smaller states have to have a minimum of 3. So what do? Do you expand the House of Representatives so it can be more representative of the popular vote? Or do you keep it this way? And is it constitutional? What do you think about that? Because I honestly think that constitutionally this is allowed. Our system is allowed, and you have 200 years of precedent, so nobody's going to the Supreme Court's not going to overrule that. It just happens. But I do think the argument seems to have some merit. What do you think?
Well, yeah, I mean, my view is I actually have a contrarian opinion to Baker v. Carr and some of the rest of it. The best part of their argument would be that the old analogy was state governments determined that they were going to operate by a county mechanism of government within the state. So each county was an independent sub-constituent component of that, and each county would get a certain number of votes. And so one person, one vote came about because small rural counties within a state had disproportionate political power over urban centers because of the one county, one vote effectively.
That was Tennessee. That was in Tennessee, right? It
was Tennessee,
Memphis,
and there was one other state that had that same principle. Now, what you also had was a lot of, it may have been Texas. You had a huge political and cultural difference. So those similar arguments about, hey, the Electoral College was designed to protect the rural way of life, small town way of life. We want geographic diversity. None of that was really why it exists. I mean, my view is basically these states were going to be independent countries. Yeah. And we convinced them not to become independent countries in exchange for giving them rights that they would always have in terms of the Senate, in terms of the House, and in terms of the Electoral College. And so, in my view, that was the deal we cut. And if we want to change that, we have to change the Constitution. My view was the same about whether with state constitutions. And Baker v. Carr, I thought they should have forced the states to change their constitutions to change how they divided up power. Those state constitutions had chosen to give disproportionate power to rural and small counties. And I thought that was really their prerogative at the time in which they did it, unless you could show there was some problem with how they set that up in the first place. In some of these states, there was a good argument that this was set up in a questionable political way, because almost every government from 1861 to 1873 South has question marks by it. But it gets into 14th Amendment, 15th Amendment issues.
Because Baker v. Carr was a 14th Amendment issue, right? Equal protection clause.
Exactly. And part of it was, what's a state? We were saying a state is so-and-so, or we were saying these senators represent the state. Did they really? Some of these provisions that were passed in anti-democratic ways. So I thought there was a way they could have got to the Baker v. Carr issue without doing it the way they did it. But it is what it is. But I think there is the argument against the Electoral College is that Baker v. Carr argument that says, hey, look, we already went through this once. The state said they could divvy it up by rural county.
You're moving up.
You said no, so let's just apply the same logic. I think the big difference is the counties didn't form the state government. The state formed the counties.
Correct.
The states did create the federal government, and they created it on the precondition because they were all scared that, hey, my little state is going to get run over by the big state. So, and they're mostly in the South, they were all worried about Virginia dominating. In the North, they're worried about New York dominating or Massachusetts dominating. You know, my forebears were all from Rhode Island. We didn't even vote for. I mean, we voted down the Constitution, and yet we were told you had to be stuck back into it, despite what the Articles of Confederation said. So arguably, we're still free. But you know,
that's the sovereign citizen. The Constitution is
exactly. So now my forebears also made the Amistad argument. There were friends and family members of mine that were arguing that once free, always free, which led to part of the Dred Scott dissent decision. That's what made Dred Scott so wrong. They're once free, always free. Then that's always the case. Goes to Lysander Spooner. The unconstitutionality of slavery with Frederick Douglass, 1842. But there's a whole bunch of different arguments on that side of the aisle about the scope and scale of the Constitution. But yeah, I think as to that question, there is a one person, one vote principle. But I think we are basically like the EU. We're a bunch of countries put together, and we agree just not to exert the full sovereignty of being an independent nation in exchange for protected rights as individual states. And each state that was added to the Union, we said you get those same rights as the original states of the Union. So it would be a violation of our confederation of states within the United States of America. As I always tell people, we're not United America, we're the United States of America. And that's the way our Constitution was formed. And maybe that has problematic aspects now based on population patterns and cultural preferences in different areas of the country and so forth. But the best way to change it is change the Constitution and go from there. And if that doesn't work, well, then there's other, you can try other remedies. But I think that should be the one for now.
Yeah, I agree 100%. It's great.
Okay, we got. I missed this super chat on the screen and I can't scroll back up. Shine 01176 says, Robert on Romney, Reagan, the 9 most terrifying words in the English language. I'm from the government. I'm here to help. We know that old joke. AM says Utah state government is trying to pass a bill to recall senators. Is it legal for the state government to recall a federal representative?
It's not, because of the Senate has an explicit 6-year term under the Constitution. So it's going to go back to congressional term limits. And on the same basis, they've said that the states cannot. So they interpret recall provisions to violate the Constitution's tenure provisions. Now here's the other flip side. It hasn't really been tested that much. It's only been tested sporadically. It was most recently tested in the congressional term limits when states were trying to impose term limits on how long their congressman could serve. The Supreme Court said, no, you can't do that. That's exclusively a prerogative of the Constitution and the U.S. government. So right now, it is unlikely that you can recall a United States senator. My argument is the whole point of direct election of senators and passing the amendment to do that was to give people the power, including the implicit power of recall. But it does contradict the length of tenure provisions in the Constitution, which were not changed with the direct election amendment. Yeah. So the better argument is probably opposite me. It's where I would like the law to be. It's not likely where the law is yet. Or where it necessarily is in the plain. Again, it's a place where a textual interpretation of the Constitution takes away remedies you might like to have politically. I would like to have a recall option. It's just not in there.
But I also wanted to speak about, because earlier, Viva, you mentioned in one instance when it came to I forget like in one instance I was a textualist, but the other instance, but because. And for high crimes or misdemeanors, for instance, the reason why the argument isn't, because I can see that the textualist argument, I can see that crimes being crimes, but the argument was about the interpretation, who gets to interpret what that means. And the Supreme Court and the precedent, which just it is what it is, they've allowed Congress or the House of Representatives to be the people who interpret that, versus whether the presidential impeachment is different than judge's impeachment. That is just a textual argument, because there hasn't been an adjudication to say that these are differences. There's a difference here. So I would lean more to the textual interpretation, because just read what does it say on the page versus something that has been changed over time.
No, that's actually a fair enough response. All right, so we got Noof NEWF 666. I don't know if anybody can see this. $6.66. It says YOLO. Thank you very much. There's one I want to make sure I can get. Nate, you are dead wrong. Okay, good. Here we are. Okay. Nate, you are dead wrong. Utah is really mad at Romney. He barely won the primary, and he's almost 100% going to get voted out of office. He is done. Well, this is where my, not, I won't call it conspiratorial, my gut instinct was that I think he thought he was going to get voted out one way or the other, and this way he gets to go out a martyr who has fulfilled his vengeance against Trump, who he hated from day one.
Well, hold on. Two things though. Romney just got in, so he's got another 4 years to go. So if Trump has to get elected again, and then you talk about getting Romney out. So 4 years is a long time, right? And number two, Romney got in on an I hate kind of Trump kind of thing. You know, he had voted against Trump. He was there and going to be the check for Trump and got voted in. So maybe this person may personally dislike Romney, but to say that he's not popular in Utah, I don't think is accurate.
What is there's been conflicting polling data out of Utah since the election. So you had Romney be very anti-Trump during 2016, do that speech in Utah where he bashed him in every single possible conceivable capacity. Then after the election, Trump sort of lured him in with, hey, maybe I'm going to make you Secretary of State and show the world how you'll crawl on your knees for political power, and then I'll reject you for kicks and giggles, which is what he did. So Romney decides to go back to Utah, and it cannot be understated that he is what Obama is to African-American voters, what John Kennedy was to Catholic voters, Romney is to Mormon voters. Yeah. He was someone who legitimized their faith in the public arena by being a near president and nominee of a major party as a Mormon. Now, his political history goes back to his father was a sort of cantankerous moderate governor from Michigan, was anti-Goldwater, anti-Reagan. He comes from that whole family line. So the fact that his dad would do this kind of stuff. So it's not a real surprise that he's this sort of a lot of times it would seem out of ego, just because even if it wasn't out of ego, he didn't prep it like it was anything other than out of ego. So there's an open discussion about how much it matters. Now, this is where senatorial terms being 6 years have consequence. And going back to one of our earlier super chat questions, clearly the founders set up the Senate to be very independent. My view, too independent. Again, I go back to little d democracy. I like more checks on public officials. I don't trust anybody once they get to Washington. But we're the decaying, dying Rome of another age, another era. But that's just my own political preferences. Clearly, the founders set it up so that they would be almost immune from public will. I mean, they weren't even directly elected initially, of course. Now, here would be the argument for recall, and related to Romney, would be that back in the day, state legislators could recall senators. So it's like, if state legislators could recall senators, why can't the public, now that it's direct election, recall senators? But it gets into those term limits cases where the court seemed to take a much more constricted interpretation of things.
And the constitutional amendment too, that you have to deal with too. So
right. So I think there's a poll out there that says Romney is getting crushed in Utah. There's polls showing Trump has rebounded in Utah. There's the older polls from 2016 where he did not do well in Utah, huge independent vote in Utah. I think the biggest thing of Trump fans that are from Utah, like probably this gentleman is what it was is during the convention stage of the 2018 Senate Utah race, Romney lost at the convention. So there was a lot of the activists didn't like him because of the Trump issue. And then that person was going to run against him in the primary. And that person lost all momentum because Trump came in and endorsed Romney. So for that wing of Utah Republicans that were supporting Romney's opponent, who attribute Trump's endorsement of Romney to why Romney won, it's open question whether it had an impact. Like I said, my view is, once you're the first Mormon nominee for a major party, I don't see a Mormon state voting against you anytime soon. But their view is otherwise because of what happened at the convention and what was happening in the primary until Trump's endorsement. It is another question. The one good criticism of Trump in all of this from both sides that I think is fair is that Trump has got himself into this trouble by whom he has hired and whom he has chosen not to fire. There's a reason why day when Obama got in, he said all diplomats now fired. He said it nicely, gently, sent them a little letter. By the way, you're all gone.
But that makes sense, though.
Absolutely, it does.
Yeah.
Trump went in thinking, oh, I can negotiate with people, I can get along with people, I can show them why I'm right. And he left a whole bunch of people who politically despised him in positions of power. And another example of this is endorsing Romney. He got nothing for that whatsoever. He made the same mistake in endorsing Luther in Alabama, which just led to Roy Moore getting elected, which in turn led to a Democrat, Doug Jones, getting elected. So the people around him, I've been high profile in a wide range of settings saying that, when he lost Bannon, he needed someone like Bannon around him because you can't be the sole general. You need other generals on your side. He has none in the White House. Apparently they were totally sideswiped today by Romney. They were going to do a press conference today after the acquittals. They canceled them because of the Romney vote.
The one vote, yeah.
Exactly. And it's like, how did they not know that was coming? The guy was yipping to half the press in town that this was coming. You could watch his demeanor and know this was coming. And so I think that I was unimpressed at how he did it, in the sense of I would have structured the narrative so that it looked like, even if I wasn't really conscience-stricken, I would at least look like I'm conscience-stricken by being proactive, asking questions, being involved in the public debate, discussing it on both sides, etc. Not in the minds of Republican primary voters like this guy maybe from Utah. They're totally shocked. They had no idea. And they feel betrayed. They feel he betrayed the president, but he also betrayed them. And that's what's, it's I'm not sure who his audience was. If his audience was posterity, he didn't do that great of a job. If his audience was the Republican base at home, he didn't prep them well enough. If his audience was the media, short-term win. The New York Times will make him man of the year, maybe.
Of course. Yeah.
But exactly. But that's about it. It's like, okay. I mean, mostly I think it was really deeply personal. He's like the prep school kid who Trump used to beat up when he was in third grade. That's why they sent him off to military school. He used to beat up all the rich kids at his local school. So it's the same demeanor.
I'm going to take the Viva up to. I have a conspiracy theory. I think Romney still wants to be president. And I think,
probably true.
And I think he wants to have his cake and eat it too. I can lash it at Trump if Trump loses, which most people think he's going to lose. That's up for debate. But if he loses, then 4 years later, I was the guy in the middle of the road who crossed party lines who voted for Trump. Now you can vote for me, because he's always been that. Don't forget Romney cared before Obama cared, and so he's always been that.
Well, he was pro-choice before he was pro-life. He was for gun
exactly.
control before he was against gun control.
So this could be he could be playing the long game here. Okay, 4 years. I have just 4 years. If this guy doesn't make it, I have a real shot here.
Well, it might be the Ted Cruz mistake from the Republican convention. I discussed it with a bunch of friends of mine who were close to Cruz in that speech. And I said, that speech is a debacle. I said, watch by fall, he's going to be begging Trump to be calling for him a local phone call. And that's exactly what he was. It's because the political establishment is completely disconnected from the broader audience out there. It's a very much let them eat cake environment in D.C. They have no idea what the people beyond the castle walls feel about them and feel about the system and the rest of it. That's why they're shocked by Bernie on the Democratic side.
Amazing. Okay, hold on. I'm gonna burn through some of these. Now we got Jason L that says nobody argued to impeach Obama, and he turned the entire security apparatus onto Trump. The gross FISA abuse happened under his watch. Remember, true. We got that. Yep. I mean, I'm
all for impeaching John Brennan just to try to impeach him. I don't think it's constitutional, but just anything to make John Brennan's life miserable, I'm in favor of. And I would love to see a CIA official finally held responsible, probably for the first time in American history, because I don't think it's ever happened. It's not going to happen.
Security clearances. You can't get through security clearances.
Yeah, precisely.
Joe Ward says, thank you, Viva, for answering. If Obama had done this, I'd say impeach him. Just thank you. Okay, hold on. We got Tom Rader says the Dems have been screaming impeachment since he was elected. Terrible precedent. I think. By
the way, that was dumb politics on their part.
Well,
they should have played that cute. They should have played that quiet. I get why. Look, they knew they had a hard part of their base that was enraged at Trump and just in a way that even only probably the hardest core conservatives disliked Obama. I would say it's more like Clinton. And W. And it was W had a hardcore group of liberals that hated him. Clinton, who had a hardcore group of conservatives that really despised him. I mean, it bred a lot of new media was just hating Bill Clinton. A lot of Newsmax started by one guy who hated Bill Clinton. He became famous and rich through it. So I think that it was a political miscue on them to do that. In other words, I think that it was short-term advantageous, but long-term disadvantageous. They could have set the plate, well, if they would have said, hey, we want to work with them and we want to help and we want to do things. And then they're just disappointed and shocked at the terrible things he turns out he's doing. That's a better story narrative build, a narrative arc. They're skipping to the end over and over again, and they're previewing the end at the very beginning of the movie. And so it's not a good film narrative structure, I thought, from a political perspective. It worked for their base. It just made it highly unlikely they were ever going to get crossover votes the way they went about it. That's how they lost Murkowski. Also, Warren asking that question to Roberts to embarrass him in front of the whole world.
I thought his response was beautiful, though, because he's right.
Oh,
he's
it
like,
was.
I'm an unelected judge. And you guys have to go when you guys have to go and respond to the people. The people are going to say whether your votes here matter. So his response was beautiful, and it was right off the top of his head too, which shows you that's the reason why
he had thought it through and thought in advance. But it was a lot of that, and I got part of it. I was like, okay, maybe they're playing to their own base is the way they're doing this because it's a foregone conclusion in their minds about what's going to happen. But I thought that from a storytelling perspective,
it's tasteless. Come on, why put the Chief Justice out there like that? That's ridiculous.
And knowing that people like Collins and Murkowski really, that's he's their kind of guy.
El Rojo Grande said, would Nate have supported an impeachment of Obama for his extrajudicial assassinations of American citizens abroad for which he is being sued by the ACLU?
If you're assassinating American citizens, yes, I would support your impeachment if that was proven. So if Obama was doing that, I would support it. I would have supported his impeachment. If Trump is doing that, I would support his impeachment.
I assume what they're referencing is the drone stuff overseas.
Oh yeah.
So and that was always interesting because I think it's one of those places where Americans are split. There's the 24 TV show side of their personality that's like whack the bad guy. Don't worry about due process and and then the side of, well, what if that happens to be me down the road? And a president decides for whatever reason I'm now politically unlikable and I can be killed overseas based merely on an accusation, not based on any. I haven't been criminally convicted of anything. I've been bothered by all of it. I didn't like any of the W regime. All the way through, I'm not in favor of this kind of secret subversive state power. It's one area where I strongly disagree with Trump. Trump is clearly on the side of that's where people didn't realize he was highly unlikely to ever pardon either Julian Assange or Ed Snowden. He's a national security hawk. Now he's an anti-war national security hawk, and that's what throws people off. But so was Colin Powell. So was Eisenhower. A lot of your strong national security people think the way to avoid war is to have an invasive national security state, to bomb a lot of places, to have coups in a lot of places. Eisenhower had more coups than almost any president ever under him. And it's because he thought it was the way to avoid military conflict, on the ground conflict. So it's I agree with Trump's anti-war inclinations in terms of boots on the ground. Not so much. I've mixed sentiments on the use of our power overseas. I like all the movies where we go whack the bad guy. We don't worry about due process. But as a constitutional lawyer, I don't like the lack of due process in the end. So conflicted on it in the end.
Okay, very interesting. We got AM says, out of topic question, why are residents from other states allowed to interfere in another state's election by funding candidates outside of their state? Many elections won by out-of-state funding.
Yeah, you have a First Amendment right. I've litigated some of those cases. So
Citizens
you have
United.
Absolutely. Even before that, because I did it in a different context. I represented out-of-state petition circulators.
Oh.
So the main source of petition circulators for independent and small campaigns and for not well-funded campaigns are out-of-state experts, people who are either committed to the cause or are very affordable because of how efficient they are. They know how to persuade. They're just those people can walk out in the street and persuade anybody to sign a petition. I had an old friend of mine that was sort of on the independent anarchist political right, but he's one of the best petition circulators for any ideological cause across the country because he'll do it because he believes in ballot access. He believes in little d democracy. We share that in common. And he's persuasive and he knows how to persuade someone. He's like, even if you totally agree, don't you think you should have opposition on the ballot? Don't you think you should have the right to decide yay or nay, not somebody else? And he's just great at getting signatures and good at getting authentic signatures and avoiding problematic signatures. So the same rights apply. So the right, it's protected under the right to travel, actually. U.S. Constitution was meant to protect interstate travel, interstate commerce, and as part of that, they have said that includes your right to influence elections in other states. And I understand the question from a sense of principle, because the person's like, hold on a second, I'm being told. I also have a contrarian perspective on quote unquote foreign influence for the same reason. The person's looking at it and saying, I'm being told it's terrible if some foreign government, like say somebody from Canada, some dangerous place like that, they started getting involved in U.S. elections, and somehow that's a bad thing. So why isn't it a bad thing when Californians decide to elect my congressman in Middle Tennessee? So they're right from a policy perspective. A lot of the same logic would apply. And in my view, that it does apply partially in the federal context, in the foreign context. I believe people of anywhere in the world should have a right to try to influence U.S. elections as long as it's transparent and open. They can't make donations to U.S. campaigns, and I agree with that limitation. But I think they should be able to spend money on political ads. I mean, and the reason is, let the argument be persuasive or not persuasive. I believe everybody should have free speech rights when they're inside the United contours of the United States, no matter where their residency is. One of my arguments to my friends on the left is, if we really start applying these rules, these new foreign donation laws and the way they're applying it, and calling any foreign interference bad, well, the number one group of foreign interference is, without question, whether if you're on the right, you say illegal immigrants. If you're on the left, you say undocumented individuals. Whichever terminology you use, they're foreign nationals. Yeah. And they are by far the most active group in terms of numbers of individuals trying to impact U.S. elections. I don't have a problem with that. I may disagree with what the scope of immigration laws should be and so forth, but I want the debate to. I trust ideas. I don't trust any rule that in any way restricts the ability for any person to communicate their ideas. For two reasons. I want every person to have the full right of speech, but as important as part of the audience, I want to decide the quality of the idea by hearing from all these people. I don't want the government to say, well, this person's from Russia, this person's from China, this person's from London, this person's from Canada. You know, it was like South Park, right? They make the whole thing about, we got to make sure Canadians don't invade us. You know, because then when we look at it, we're like, that's an insane proposition. So that's my view. It becomes real nebulous once you start talking about foreign influence. What does influence mean? Does influence mean my uncle that lives in England, or I have a client that as expatriated no longer can be involved in U.S. politics? What is influence? I like limiting it to you can't directly donate to campaigns. You can't do, and if you lobby, you have to register and announce it to the world. I agree with those two provisions. Beyond that, I'm for more speech, not less speech.
But Robert, wouldn't it seems like the two things we're talking about here? One is constitutionally protect the privileges, and I'm not sure if it's and or privilege and immunities clause, travel, so you can affect, versus foreign nationals where
who are not protected by the travel clause. Yeah.
So I think that seems to be the key difference between.
From a constitutional perspective, no doubt. The First Amendment may apply, but generally only applies if they're on the continent, on the United States itself, not if they're outside the United States, even if they're a foreign national. It's more of a policy perspective. Okay. Which is that I think that foreign nationals should be able to participate in U.S. elections more so than we're allowing them to do now. That right now, and we've created this bugaboo about it. Now I don't even understand that. I'm like, why are we scared of ideas? Why are we scared of the public being exposed to ideas?
Well, I don't think that's the issue. The issue is, like, for instance, what was happening here in New York. Like, it's not the fact that people are the ideas are coming, but you had I know it's probably going to make the chat and say, but like the Russian troll farm, they were particularly like, and it was something funny with Black Lives Matter. It shows you how gullible Americans are. There was the Russian troll farm. What they did, they set up an online Black advocacy group like Black Lives Matter. So they set that up, and come to find out, it had more members in the Russian troll group than the actual Black Lives Matter group did. And what they would do is the Russians, to show you how clever they were putting out false information to this group to make them just go do like crazy stuff. Oh, fight the police, do this, because they wanted tension within it. And that's why now they were saying that, it wasn't the fact that the freedom of information, it was just the freedom of manipulating information, bad information, to make people do things that they want to do. And it was going to the point where I know in Harlem, for instance, it had happened that to incite violence against the city, against officers, against law enforcement. What the Russians were doing was they would pay like dojos and different type of martial arts centers around the neighborhood. They would say, okay, hey, we want you to train 20 people. And we're going to give you a grant just to do that. And the people are like, where's this money coming from? Don't worry. We just want, we want to help the neighborhood out. We're going to give you 20 free spots. Go train. And they did that to a whole bunch of places. And come to find out, it was the Russians because they wanted people to have this be a little bit more combative. So that, I think, is the fear when you're talking about outside interference, because you do have that type of nebulous thing to say, hold on, we want to actually do harm to these people, not to give them information to challenge ideas.
Well, my view on that is the answer is always transparency rather than suppression. I don't have a problem with them doing that as long as everybody knows, hey, that's a Russian troll farm that's behind this. If they've hidden that, then that can be problematic. But the other factor is that Americans should all recognize the king of foreign election interference is the United States of America.
I was going to say, again, I'm not bringing it up because I have a problem with it. But when Obama tweeted out his support for Justin Trudeau, how would that not be the very same foreign election interference that America was complaining about? I have no issue with it. Again, like, let him do it. I'm not sure if
Robert Barnes, that's exactly what he said. You're right. We are the biggest ones on the planet.
And I mean, the State Department, that's all they do. I mean, particularly that was the irony of this whole what was fascinating is because there's bipartisan support of an agenda that's really different than Trump's agenda on Ukraine, neither side talked about the backstory of Ukraine and how this is really a controversial policies that we have had in Ukraine. Like they're saying, they're right that the House and the Senate and the national security apparatus have a shared agenda with Ukraine, but it's not clear that the public has any clue what the scope and scale of that is. I mean, people don't realize we overthrew one government in a coup. We helped sponsor it. We created fake news stories about who killed who. I mean, and this doesn't come from it comes from parts of the right, but it mostly comes from the left. Oliver Stone has done a bunch of movies on this, including Ukraine on Fire, that people can look up and make up their own mind. But it was because I knew people from that region. I knew some of the background and the backstories there. I knew the whole political. The U.S. and Russia have used Ukraine as a toy for years between each other, and the idea that anybody in the national security apparatus cared about Ukraine in this context, I found very dubious, because it's unfortunate. I mean, we wouldn't have been lining up with both the Obama administration and John McCain stood on the stage of two guys who are proud to be neo-Nazis in Ukraine. I mean, that's how insane it was. When I first heard that, it was like, that can't be true.
But Robert, Ukraine has it's because of the military strategic placement of Ukraine. It's a straight shot to Moscow. It's a straight shot to Moscow.
And you have oil that goes through it too.
The Caucasus,
which amazingly, I guess, according to the tape, Trump didn't know. So I was like, that was fascinating. It's like, oh, Ukraine has oil. It's like, I know it was a poor country. I was like, it's fascinating. Which it piqued his interest because, as Jimmy Dores on the left says, what he likes about Trump, even though he totally disagrees with Trump, is he sees Trump as what people on the right say about Bernie. That he says exactly what he's thinking. They're very straightforward. They may disagree with their positions, but he was using as an example the way Trump talks about oil overseas. But that's the irony, is this whole debate was about whether we're protecting public policy in Ukraine, when in reality it's about whether we should have ever even been there in the first place. There's a reason why Obama was not sending military aid, is because he had second thoughts about whether, do we really want a civil war on Russia's border? Is that really a good idea? And really that was Trump's position going in, and he actually reversed himself. And then halfway through was like, I'm not sure where I'm going to go. Maybe I can get useful information to find out what happened in 2016. Maybe I can get useful information about Biden about all this. But I think down deep, Trump would have never approved military aid for Ukraine if it was up to him. He felt pressure to do so, and so did so.
Well, it passed overwhelmingly. That's the he had no choice.
Right. That's right. There's a bipartisan agenda that the public doesn't even know exists.
Yeah.
We got Pot Stuck says we are due for a convention of states, do some updating on Electoral College if possible, and fix that horrid direct election.
I've heard from both the left and the right this idea. The constitutional personality of me would love to see that kind of thing happen. The practical side of me would say it's much more risky than its reward. And so it would be great to hear the debate and the argument back and forth. But if what we saw in the Senate is any kind of example of what we would see now, we're going to see the Dumb and Dumber version of the so I'm not in favor of round two. Not at this stage.
Oh my God.
We got another one. Mark Mace. Question to Barnes. Noted a comment way earlier where you espouse direct democracy. 84% of Americans live in urban areas. Should cities run the U.S.?
Well, I believe in direct democracy in terms of people having the most power, but I agree with the compromise the states made and that we should honor that compromise now. What I would say to all my conservative friends is, what if the shoe was on the other foot? What if the urban areas were all conservative and the rural areas were all Democratic? I suspect 80% of my conservative friends would have a different opinion on the Electoral College. So my view is the same either way. I believe in direct democracy, more power to the people. At the same time, our Constitution formed because a bunch of different people were within a state, and as part of that condition of saying you give up your independence and your international sovereignty to join us so that we're more collectively powerful than you could be individually, we should honor that deal. And part of this also reflects my view on Native American rights. So my Native American, my Indian tribal law professor, Richard Monette, has articulated a very smart and savvy legal theory that Native American tribes' treaties with the United States government should be put on the same footing as state governments and be given comparable sovereignty. And you would have an immediate rubric of rights and protection that we've already well developed in the state federalism context that could then be applied, that could give expand power to tribes on a fair and justifiable basis. So that's another reason why I have the same articulation. It's how do we balance direct democracy with individual rights, with ancestral protection? We have these ancestral provisions that say if you're part of the state, you're going to have certain protections because years ago your forebears forewent being an independent state. I think we have to honor that. And at the same time, we can protect, but within that context, we can maximize individual empowerment as much as possible. Now, we live in a very constitutional republic that has multiple checks and balances. And there's aspects of that I like. But it's just, if I have to choose between one side or the other, the side that ends up being more power to the people is the side I'll lean on.
And just a quick note too. I think Indian reservations and Indian tribes who have the designated land, they do have sovereign immunity, right? They can't be sued in court, whatever. And so
it gets real tricky. So there's constant battles between them and every state government. So like untaxed cigarettes always becomes a constant area of conflict.
And casinos.
Yep. And when cops cross the border. It happens frequently. So it's basically that his idea of tribal rights, of tribal federalism, if you will, would have created an easy architecture to plug and play and dramatically expand, but give meaningful limits to tribal rights in the country and to meaningful sovereignty. And also it would politically, I thought, be more sellable. So people in the state, they're saying, hey, they're a tribe, just like Rhode Island is a separate state. So that's why we respect Rhode Island as a separate state if we're nearby, if we're Connecticut. In the same way, we're going to respect the tribe as if they're Rhode Island. I thought it was a very smart and savvy way. Ironically enough, people on both the right and the left criticized them because it offended some other political agenda they had. But I thought it was by far the best articulate version of that.
All right, and I missed a couple of super chats. I'm going to get to my phone. Sure. Tater Raider, we have a new member, which is very cool. I haven't seen that icon come up. Night Wolf NWC says, if Trump loses the election and the Democrats try to remove the Second Amendment, either by vote or executive order, will there be a new civil war? I don't think
there's no possible way they're going to remove the Second Amendment. That's just not going to happen.
I mean, I think there are people who like Bloomberg, I think really believes that the Second Amendment should either be dramatically reinterpreted or withdrawn. But there's no way that they're going to amend the Constitution to get it removed. No. So that means the only way is have the courts redefine what it means different than how they just defined it within the last decade. That is highly unlikely.
Especially with the makeup of the court. It's just not.
Absolutely. Yeah. I mean, that's where I'll give. Trump was trolling big time at the State of the Union when he's talking about, look at all the judges I put in, and more coming. That was his way of spiking the punch in response to impeachment. He wasn't going to talk about impeachment. He was going to talk about all the stuff he's going to do as policy payback in his view.
And Tater Raider, the new member, super chat says, in politics, everything is a political tool. That doesn't mean every tool needs to be used.
Of course.
Yes.
We can agree with that. We got Jason L., who I'm now caught up to on the screen, says Obama droned a 16-year-old whose father was a bad guy. Obama's campaign said he should have had a more responsible father. I mean, I think we know
Obama's like the third killing that president. Doesn't he have people to do this? Is he doing it himself?
This was all the drone stuff.
The drone stuff.
That's what all this is. There was actually a quote by Obama in one of the books that said, where he said, it turns out I'm really good at killing people. It was I think he had ambiguous sentiments about the drone warfare himself. He went back and forth on it. But Obama himself said the biggest thing he did was standing up to not going into Syria and how much pressure that was on him.
But
that gives an idea. Trump just a couple of weeks ago said, or a month ago, said, there's a military industrial security deep state, and and you have to fight them every day. And that's just the nature of the apparatus. It doesn't matter who gets elected. Our administrative state has so much power within the national security apparatus that when you combine the amount of money that's tied to that in the outside defense contractor world, any president is up against it. I consider any restraint on war a good thing, even if it's not as much of a restraint as someone like myself would like.
But I it's funny because now I feel like I have to disagree with Obama, which if you're going to announce a red line, you got to honor it. You know what I'm saying?
I'll agree.
And it's just, and don't get me wrong. I think, there was a political blowback for that, but I do agree that you can't leave people on the field because people were depending on the United States to do it. So, you have to just do it.
I think he was constantly caught in catch-22s that Trump has mostly avoided in extraordinary ways. But Ukraine is a species of this. I said the real battle here behind the scenes was a national security battle of the national security apparatus and Trump. It was almost like the Democrats went along with this impeachment because the national security apparatus wanted to send a message to Trump as much as their base wanted to send a message to Trump. Because in 2018, they'd avoided talking about impeachment the last 6 months because they knew it was going to end like this. And they found that it brought out Trump's vote. Trump has raised an absurd sum of money off of this.
Of course.
And much like Clinton, because if people aren't really into the impeachment, just being impeached and you keep doing your job, it makes you look better. Yeah. It's amazing Democrats have forgot that lesson from Clinton. I think they thought it was unique to Clinton. It's not. Trump is now at the highest job approval he's had his entire presidency.
But the reason why I think the Democrats made a bad choice, but I think with Clinton, the Republicans had no choice.
Oh yeah,
you had no choice, and all those Democrats who voted against it.
Also, Ken Starr created undue pressure. Ironic to see him back in this one. I agreed with his arguments in this one. I think he should have applied it better back when he was independent counsel.
Yeah.
That he put pressure on them unnecessarily because he didn't have to send that to them here's what should happen.
But it's the independent counsel statute. Don't forget he became a fourth branch of government. If that's the reason why they got rid of that statute because they said it was way too powerful.
Insane.
It started with it started with a loan and ended in the White House with the
and hopefully we'll get rid of special counsels the same way. I don't like any.
But special counsel has a lot of it's a lot less powerful than independent counsel. Independent counsel
is a huge
as much money as you want and all that stuff. So
gigantic improvement. But we're half here today with this impeachment because neither side was satisfied with the way special counsel.
Yeah.
Okay, so one comment, then I've got a question, and then we should probably wind it up. It's 2 hours.
Yeah, I forgot we were like talking forever here.
It says the newspaper, radios, TV have been running ads by foreign groups for over 100 years. What about their interference?
Yeah, and especially these days, it's almost impossible. Like Rupert Murdoch is a foreign national. I mean, it's like, how do we start limit? I'm just like, I just want transparency. So no one should be able to hide and claim to be one group when they're really another group. That's misrepresentations, things like that. Expose that. Otherwise, Israel spends a lot of money here. Not only that, all the Middle East, if you go to DC, everybody that's setting up a think tank, everybody that's setting up a publication, everybody that's setting up a podcast, even any of those things, they're looking primarily to not U.S. citizens, but foreign governments for their support. So it's like 2/3 of D.C. has already been bought and paid for by foreign governments, and we're worried about what grandma is reading on Facebook in Iowa. I'm much more worried about and like if you want to see D.C. totally change their mind on foreign influence, ban foreign governments from supporting any form of NGO, think tank, or charity.
Then all of
a sudden DC would be like, well, I need my cocktail party next week.
Okay, now here is the question which we can end it on because a lot of people are wondering it. Nancy Pelosi tearing up the copy of the State of the Union address. Did she break a crime? There's a meme going around on the internet that she destroyed an official government document, that she may have committed a crime.
Remember, that was my other argument about Trump and impeachment. I was like, if you just follow a crime a day on Twitter, how in the world could they not find? I mean, given what they believe about Trump, I didn't think he did anything wrong. That's my own opinion. But put that aside. Let's say you think, as they do, that he did something wrong. How can you not find a crime when there's like 10,657 crimes these days? There's got to be something he did wrong somewhere. But they're technically correct. That is an official document, supposed to be officially stored in the archives, and she destroyed it. What she should have done was she should have done the John Kerry thing. Don't bring the real trophy. You bring the fake one. You throw that away. So she should have brought some fake paper. She still could have been dramatic. Obviously, I don't think that should be a prosecutable crime or anything like that. Who's a prosecutor? Yeah, we have way too many crimes already that are on the books and insane. I mean, there's crimes regulating how you fish, where you fish, when you fish, what kind of thing you send out on this date versus that date. We got nutty laws. As Huey Long said, we got the ABC agency to regulate XYZ and the XYZ agency to regulate ABC. So I think, but they're technically, I mean, I love social media for that sense. Only they would sit there and think, I wonder if that's a crime these days, and look it up and go, holy cow, there's actually a law that covers that. They're technically correct. It's not anything anyone's going to do anything about it. No. Obviously, I don't think it reaches the standard of materiality. It's not going to impact actually the way that's designed so that actual official documents, that's the only copy of that document, doesn't get destroyed for chain of custody purposes. That's, she has a ceremonial document. That's
And let's not also forget too, there's a political cost to pay for doing something like that. If you were to do that, then you make Nancy Pelosi look sympathetic. Now Trump looks like a horrible. So there's a huge political cost to pay for that. And Trump now has won. So what? And I always tell this to clients: you got to know when you've won. Stop exactly. Digging the hole. You know what I'm saying? Have you ever had that client talk with a client like, come on, we've won everything.
Well, if they win too easily, often I find they don't learn the lesson from the case. So the nature of the animal. But and also I think her meme slightly backfired because the impeachment vote was today. A whole bunch of Republican congressmen had articles of impeachment and they were tearing them up, saying acquittal, so it's now going to become, there's going to be elementary school kids doing this. I don't know if your kids are going to be doing it even if they watched it, but they're going to be, whatever, Dad, just tear it up. If the Speaker of the House can do it,
Okay, we got super tampon 5. Can Congress impeach an entire Republican administration to install Democrat Speaker of the House to presidency?
Yes, they could. They could impeach both the president and the vice president. And if they successfully impeached and removed both, then the speaker would become the president. Interesting.
Very interesting. And there was one more that I saw here. MX50. Seems I joined late. I was hoping to see blood. So this is a good what's the word, catalyst to end this, because
the
funny thing is, and I was talking with someone who gives me some insight, and she said, the funny thing is, like, when we refuse to be able to acknowledge that somebody else's view of the world can be as legitimate as our own without it having like some sort of devastating impact on our view of the world, because if somebody else could be right or legitimate in their beliefs, it sort of undermines our own ability to be right and legitimate in our beliefs. And these things that's where people have a big problem, is appreciating that someone else could legitimately believe what they believe, whereas we could still believe what we believe. And the funny thing is, listening to Nate and Robert talk, I don't think you guys disagree on much. You just ultimately agree on where you disagree on your vision and interpretation of the Constitution.
It's interesting because I think we both agree high crimes and misdemeanors textually means high crimes and misdemeanors. I think we believe on the words actually have meanings. If you go back there, we agree on that. And I think we both agree now that the state of the law now, Congress is kind of determines this, and it's an open question whether the Supreme Court would get involved. So I think we don't have a disagreement fundamentally on what's happening. We just have probably a disagreement on policy on where it should actually go. Would you agree with that, Robert?
Yeah. And I think one of the big weaknesses that we saw from the Senate was you saw a lot of people who have not had to argue the other side.
Yeah.
It's one of the I have a lot of like law clerks and interns who work for me at different times, and one of the things I try to teach them is the reason why you take difficult cases is because of what Christopher Lasch used to argue years ago, great historian, great academic, which was you don't subject your opinions to people who disagree with them in order to change your opinion. You subject them to improve upon your opinion, to understand better why you believe what you believe, to understand what the facts are, to understand facts. Because like most of the time, when do we do our best research? When somebody tells us we're wrong. That's when we're like, well, I'm going to prove that person wrong. The Google. And this is everyday conversation. This is also legal advocacy or anything of great consequence. So I think that the unfortunate thing is we're seeing a professional class and political class that has not had to argue the other side very often. And consequently, they no longer know how to even recognize the other side. I always like Scott Adams' point on this. He's like, when people say, what's your political positions? He's like, the reason why I don't give a real authoritative perspective is because I've contradicted myself on my political positions over my lifetime. Yeah. So I'm not going to assert with overconfidence that I'm absolutely right. I recognize that I have disagreed with me and consequently can recognize the validity of the other side. And I think, but unfortunately, what we saw was very few people in the Senate who could articulate that way because they lived into their own siloed echo chamber. And so I think when people watch debate, they're like, oh, this is what a debate could be. A debate could be an informed discussion amongst people who are accustomed to arguing the other side of a position so they can respect and recognize the other side while still believing in their own position. Unfortunately, it's just not common in our politics today.
Well, and it's even worse than that. I mean, I think Twitter and social media has sort of fed into that, but I think it's above all else, it's a media problem. Above and beyond trying to have an understanding and understand your adversary, what you have is the media deliberately just trying to run these spins, these sound bites, and instead of getting into the substance of it, just run the Dershowitz says the president can do whatever he can do, what he wants to get reelected, and it's in the national interest. I mean, they run these falsified sound bites and then sort of get away from having any meaningful discussion on its face. And I suspect it's always been like this, but Twitter and limited characters has made it even worse. And listening to that, like people, instead of refuting what Dershowitz actually said on the substance, the vast majority of what I saw reverted to repeating this mischaracterization of what he actually never said in his actual discourse. And it's truth. Like people have lost the ability to accurately and fairly summarize their adversary's position to properly respond to it. It's just a question of mischaracterizing it and hope they fool enough of the people who didn't actually watch it.
One little side bit, I didn't even know this until I was doing international cases, but there's an old English law tradition of the Deemster, and that's still followed in some common law jurisdictions in the Caribbean and other locations, where the judge's job is actually to repeat both sides' arguments accurately before they get to their opinion. Like our courts today would never do that because they like to couch the facts in certain ways so that it's obvious that you would come to that conclusion. It's like, what a great, that's why if you go back and read even some old U.S. Supreme Court cases used to do this most of the time, 1820s, 1830s, 1840s. You have to, you're like reading through and 2/3 of the text is not the actual opinion.
I used to hate them in law school.
Exactly.
Why am I reading all this stuff?
Where's exactly the opinion? But that was why I was like, wow, that they had a ministerial obligation to accurately report it, or it was an impeachable offense if they did not. So so I was like, that I'm for that impeachable offense.
All right, and last one we got was the tearing legal because it was on the floor. Is there sovereign immunity to having an official document?
They're referencing the speech and immunity clause.
Yes.
So by the way, that's the same one that the senator who got convicted of bribery tried to use to say, hey, I was bribed on the Senate floor, so I cannot be charged because that was speech I was engaged in when I did that bribe. He really thought he was going to win, by the way. So because it's on the floor, she does have speech and immunity. But based on the bribery decision, if it was a crime, it would be up in the air whether or not it would constitute immunity from a crime. Because what they generally said was it's immune if it's speech. But because that was the senator had a good argument. He was like, you can't convict me, because his argument wasn't just speech and immunity clause immunized him from bribery. It was that it precluded certain evidence from being presented against him. He was saying nothing I said on the Senate floor can be used against me in a criminal proceeding under the speech and immunity clause. The Supreme Court didn't like the consequences of that would mean every senator would do their bribes inside the Senate chamber.
That's it.
So they said no. But constitutionally, he had an interesting argument. It's like, if speech is immune, when it's in the Senate chamber, isn't it immune? The way other courts have resolved this is they've said it has to relate to a legitimate public interest. That's, in fact, I'll be making that very argument, just made it actually in a brief we filed in the Covington case against Elizabeth Warren. That to say, hey, here's all the bad consequences. Because, of course, I'm going to argue that, by the way, you go this far, you might as well just say they can commit bribery again.
Yeah.
And so it's a good persuasive,
yeah.
So, but yes, it goes right to it.
Amazing. Okay, I think let's call it now. It's 2 hours and 35 minutes. This was
good.
This was phenomenal. I mean, I think we veered from the initial discussion at about the 1.5 hour mark, but I think we we got all the essential points out. Robert, Nate, thank you very much. The impeachment, it's over. What are we going to do now?
Oh my God! Yeah,
it went fast. It was more boring than I thought it was going to be.
Yeah,
it had its highlights. Dershowitz for me was the highlight.
Yeah,
both sides'
agreed.
arguments I thought were decent. I was expecting a little better narration. I was expecting more public discussion of the constitutional consequence of all this. I think the public was so bored that because they need to engage the underlying content. You know what I mean? So Nixon, they could relate to. Hey, he's breaking into places. Andrew Johnson, they could even relate to. Oh, he's stopping Reconstruction from happening.
Well, Clinton was the sex and sex and intrigue,
and everything that goes with that. And everybody's had that in their life experience of a friend or family member, someone else they know. Whereas phone call with Ukraine with some guy whose name you can't pronunciate, they just couldn't. That just from a ratings perspective did not sell.
What's amazing is when this first all started, I didn't know what Burisma was. Like, this is how
most people still don't.
It is
now. I was Mitt Romney. Mitt Romney's advisor was also sitting on Burisma's board, by the way. His head foreign security advisor. That's the other reason why they were never going to dig deep into Burisma. Burisma was bipartisan. I mean, Biden could never say it, but I know he's wanting to say it. He's wanting to say, you guys are mad about a structure that everybody in D.C. is doing well with. So both sides of the aisle. So please, this is why the Senate's never going to investigate Biden. They're never going to investigate Burisma.
Because all the bodies are buried there.
Right. Hunter was the Democratic appointee. The Romney guy, who was deeply entrenched in the Republican establishment, Bush guy, CIA ties, he was actually the more influential pick than Hunter was. He was the other guy they picked at the same time period. This is why they're never going to dig deep into this. This was like what Ken Starr found with Whitewater when he found Clinton was brilliant. He said, "I may be corrupt, but I implicate everybody." So that's why he got stuck with Lewinsky, because unless he wanted to go after the Bush family, or Republicans, he had to stay away from all the really corrupty parts of the Arkansas political machine.
Phenomenal, and phenomenally interesting. But yeah, this I think this was overwhelming for the general population in terms of the nuanced details of the fact. And yeah, there's no sex acts and no breaking and entering. There's just foreign policy that people tend to be less interested in. Okay, gentlemen, thank you very, very much. Someone said we have to do the New York bail as the next discussion. We'll find something to fill the void, because this will leave everyone with a void. I
have a contrarian perspective on that too. I'm actually.
I'm going to call you the contrarian, because you always start everything. I'm going to have a contrarian perspective on this one too.
I'm actually I'm in line with the liberal reforms up there. I think we need to return bail to its constitutional origin. We need to quit sending people to prison for things they haven't been convicted of.
Well, I'll tell you this true story. I was at the Bronx DA when I was an AD at the Bronx, and one thing that was very interesting that happened. There was someone who stole a backpack, right? It was a guy who stole a backpack. And even if he was convicted on the misdemeanor, he would have gotten 6 months in jail at a max. Really, we're talking about 3 months. Right. He spent something like 2 years in prison on bail, waiting for his trial, and he killed himself in prison for this. And that was, but it exposed how horrible the bail system was, because you could spend more time waiting for trial on bail than you would have if you'd have just pleaded guilty. And that's the problem in New York.
Exactly. And bail was originally designed only to deal with the issue of flight, and the issue of flight no longer meaningfully exists. The probability of flight is minuscule. It's about 1 in a million people successfully flee. So we should not be having a massive incarceration system for people who have not been convicted of a crime, merely been accused. Exactly. At this point, purely innocent under the law, to be locked up in prison for something that may be a worse punishment than even they would get if they were even convicted, especially in an environment where flight is not a meaningful risk. Flight is a fantasy. Almost nobody can flee. There's like 3 countries in the world that don't extradite now. And if you don't, you can get around extradition easy with deportation. And those 3 countries that don't extradite, you don't want to live in. So they're the same as punishment. So this idea that someone's going to sneak out of the country and never get caught, that was a problem 50 years ago. 50 years ago, you could just go from New York to Florida and never get caught. That's no longer true. And it's less and less true every single day. And yet we're doing massive incarceration on this basis of people who have not been convicted of a crime. So what I remind people, if you haven't been convicted of a crime, you're not supposed to go to prison. That's what bail is. Bail is about, if you haven't been convicted of a crime, you don't go to prison. The only time you are restrained in any way is to secure your appearance. This whole dangerousness stuff, that's the hot issue in New York, even though it was never really supposed to be part of the bail provision, it was never supposed to be part of our constitutional bail provision until a very controversial 5-4 decision in which defense counsel was not present. So it's a place where I have a contrarian perspective, a lot of my conservative friends, except to remind them someday you may get arrested and be falsely accused. And ask yourself, do you want to sit in prison waiting for your trial? Innocent people don't go to prison. That's my view. And then until you're convicted, you don't go there unless you are a clear and present danger in a mental illness context in which we better have adequate mental health care, which we don't in this country for those people. So that's the short version of that, my position on that.
Well, that is convincing me that I need to look into this and cover it at some point in the future. And we should do another live stream on this in the future.
Absolutely.
Okay. So I'm going to end the broadcast. Everyone, thank you very much for tuning in. This was phenomenal for me, and I hope it was great for everybody else. And we will do it sooner than later. It'll be one or the other, or maybe all three of us, maybe 4 lawyers next time, but we'll do this again in the future. So checking off. Thank you very much, and see you soon.
Fantastic.